My lord, may kindly allow me to mention item number 42. It is fixed at 2 p.m. Mr. Gupta was making submissions for that Coal India matter. He has been advised rest for 1 week. He is not coming to court. If your lordship will be kind enough.
Mr. God is there.
Lord, I'm not, Lord, opposing the prayer for adjournment. But, Lord, if your lordships kindly, Lord, fix this matter,
Your
the
lordship.
urgency is that, Lord, most of the writ petitioners, they have retired. And, Lord, this is, will have an impact on their retirement benefits and, Lord, pension.
Lordship, anytime after 2 weeks, if it would be convenient.
On 27th March at 2 p.m.
Much. Great.
42.
42.
Item
Coal
number
India.
42.
Coal India Limited. Great. Lord, yesterday the matter was substantially heard. My Lord, may I say one thing? Yesterday, we all stuck in one point. What has fallen from, my Lord, even I have considered the papers. My Lord, this mandamus appeal under the latest patents is not against the order questioning the legality and validity of the order passed in contempt proceeding. The consideration would be entirely based on the writ petition. And my point of argument would be, my Lord, that the writ court failed to consider my interim prayer. And before the writ court, the challenge has been made, rather it has been thrown to an order of the Tahsildar directing my eviction from a land in question.
When did the circuit bench, when was the last date of the circuit bench?
Last Monday, my Lord. 3rd of
Last date was 3rd
of March 2020.
3rd of March.
My Lord.
The order impugned in this appeal is of what is the date?
It's dated, my Lord, 27th of February 2025.
27 February 25. And
My-
when did you file the appeal?
I have filed, my Lord, pursuant to a leave being accorded by the court. It was filed, my Lord.
On yesterday.
Yesterday.
Yesterday is 4th.
4th of March, my Lord.
Order was 27th of February.
My Lord. My Lord,
February 4th of March.
My Lord, I can understand as a practicing lawyer of Port Blair, it's me who have to come all the way from Port Blair. I come after completing the certificate, I obtained the certified copy. Those things were taken some time, my Lord. Meager time was taken. I prepared it. I rushed to Calcutta yesterday. Leave was granted by the court. Then the matter was brought within the list. My Lord, these are the few considerations my Lord can take into.
Now, when the contempt was being heard,
My Lord,
was this pendency of this appeal was indicated to the contempt court?
of the, my Lord, which one, my Lord?
Your appeal was contempt
Contempt
order
was prior
passed on 19th.
to that, prior to filing of the writ petition, my Lord. Prior to filing of the writ petition. And moreover, my Lord, may I draw, my Lord?
So you said that you were present at the time of demarcation.
No, it's what the other side contends. I have taken a plea in the writ petition that the adverse material in the form of the reports, which were the solitary basis to take a eviction order, was not given me beforehand in course of hearing.
Where is that order referred to?
I have taken in my writ petition. This point was
the order dated.
Order also that from the impugned order of the Tahsildar, certain adverse material were taken into account. Page 43. Page 43, my Lord. Page 43, my Lord.
No, রিট কোড বলেছে যে না রেকর্ড দেখে আমি অন্য ইয়ে পাচ্ছি। Directed. There the other side said that you appeared on 15th of February at the time of demarcation.
This is what they say. The record.
You are denying that.
I'm denying that, my lord. I've taken a specific stand in my writ petition.
Show us that.
My lord, prayer in the ground of attack, my lord would see from the writ petition at page 47E, paragraph 12 of the writ petition, pending writ petition.
Paragraph 12.
My lord. 12A. The respondent number 3 in a haste manner passed the impugned order as the scheduled date of hearing before respondent number 3 was fixed on 18/2/2025, as it would be evident from the notice dated 10/2/2025 issued by the respondent number 3. But before the scheduled date of hearing, the respondent number 3 herein passed the order impugned, which is in flagrant violation of principle of natural justice and fair play. The petitioner could not place his case due impugned order having been passed before the scheduled date of hearing. Petitioner intend to rely upon several documents, records having material bearing while deciding the list before the respondent number 3. But as the order impugned has been passed before hearing could take place, the writ petitioner has been prejudiced seriously. That's the first ground to challenge the impugned order. And there are other grounds, Lordship, from...
So by the order, the records were directed to be produced.
Yes, my lord. And nowhere the writ court has held, Lordship, that I was put in notice.
Now it was fixed on 27th February 2025.
My lord.
What happened on that?
On that day, my lordship, simpliciter direction to exchange an affidavit were passed.
Where is that order?
It's part of the can, my lord.
Page?
My lord would see it's an order, page 53 of the stay application, page 53.
So you are challenging this order?
These two orders, page 51 and 53, are challenged before this court because page 51 would reveal that I have sought for interim prayer. The court said that let me go through the records. Once I call it from the Tahsildar concern, it was taken care of on page 53 and simpliciter affidavit was directed to be exchanged.
Beyond সেটা থেকে কমেন্ট করতে পারছি না এটা কমেন্ট Yes, are they online?
Yes, my lord.
Yes, Mr. President.
My lord, 25th February, my lord, Honorable Single Judge directed for call for the records, my lord.
Yes.
After perusing the record, the Honorable Single Judge came to know that notice was served upon the appellant.
That preponement notice?
Yes, he received the notice. I also received the notice, my lord. He received the notice by suppressing that he filed the writ petition so that he can obtain an order.
No, that notice,
My lord.
this preponement notice was served upon him.
Yes, my lord. Original record was produced in that his signature is there before the Honorable Single Bench. By suppressing that material fact, this writ petition was filed. That is the reason the Honorable Single Judge failed to pass any interim order. I also received, my lord, this notice.
Yes, anything else, Mr. Prasad?
My lord, only to circumvent the order passed by the honorable division bench, together with the contempt application, this writ petition was filed by suppressing the material facts. One who approaches with the unclean hands, my lord, is not entitled to get any order. My respectful submission, my lord, kindly don't take it. Otherwise, my lord, coordinate bench already passed an order for demolition after due process of law. Due process of law was followed, my lord. Everything was done. By suppressing that letter, my lord, 10th February letter, the writ petition was filed.
That investigation report was not handed over to him, he says.
Everything was given, my lord. Everything was given. Original record was produced before the honorable single bench. He suppressed the material facts. My lord, lordship knows that one who approaches the court with unclean hands is not entitled to get any order.
Yes, Miss, what do you say?
My lord, we have produced the entire records, my lord. And it seems that on 12th February, one notice was given to him stating that the hearing which has to be taken place on 18th of Feb has been preponed to 15th. So this writ petitioner has got every knowledge that the...
What was the reason for preponement, madam?
Because of the contempt application, my lord.
Then?
Contempt pendency of the contempt application.
Due to administrative reason.
No, meet the deadline fixed by the contempt.
Deadline is on 5th today, my lord, and we have to file our compliance report on 7th.
Yes.
Otherwise, my lord, rule will be issued, my lord, against the Tehsildar.
Now, Miss Duff, actually the Tahsildar,
My lord,
in compliance with the order passed in the contempt petition,
my lord,
202.
my lord.
202. So invocation of 202 gives rise a person to avail of subsection 7 and 8.
My lord. If my lord sees that the order dated 15th of March 2025 passed by the Tehsildar, if my lord sees the first starting point, my lord, it's compliance of the it's page 43, my lord. It is with regard to compliance of the Honorable High Court's order, my lord.
Yes, in compliance of the Honorable High Court order,
My lord.
but he has not stated. Yesterday we are discussing on this. He has not stated that in compliance with the order of the Honorable Court, I am doing so.
My lord, it is there in the order, my lord. Page 43, my lord.
Take us to that relevant portion, Mr. Jolpal.
Page 43. Page 43 of my stay application.
Where he has stated that.
Page 45 may kindly be seen. Penultimate paragraph. Page 45.
Page 45.
5. Now therefore.
202. Yes. You come to page 202.
My lord.
Invocation of power under Rule 202 gives a right to a person against whom such power has been invoked to avail of subsection 7 and 8.
My lord, they have not availed that. My lord, they have not filed a civil suit.
This also fall within the due process of law.
My lord.
Now, what is your clarification? What is your submission in this regard?
My lord, if my lord sees 200, regulation 200 subclause 7.
7.
It's no order made under subsection 1 shall prevent any person from establishing his right in a civil court. But in the instant case, my lord, the petitioner has never approached before the civil court.
as and when you have invoked 202,
My lord.
got a right to approach the
Yes, absolutely, my lord. He can approach before the civil court, but till now they have not filed any civil suit, my lord. They can take protection against this as per this regulation 200 subclause 7, but they have not availed that.
process of
They have not filed any civil suit, my lord. And my lord, if my lord sees subclause 8, if notice of an intention to institute a suit is delivered to the tehsildar, he shall desist. There is no such notice received to us that he is going to institute a civil suit.
Page 56 is the notice, my lordship, in terms of 2028. 3 months' time would be given, breathing time, and this order will be stayed. If I file a suit, automatic stay dependency of the suit. Page 56 may kindly be seen. 2028 notice.
The order passed in the contempt application, my lord.
intimation.
Page 2028, my lord, kindly see subject.
Why stated that you are going to institute a suit?
My lord, I have a 3 months' time. I have to give a notice. My lord, the order impugned is 15 February. 3 months' time, I have to serve a notice. There's no time limit. Immediately, I filed the writ petition challenging on this ground. No interim prayer was granted. Then I served the notice also that I have a time. I'm giving you my intention to file a suit. So I have a time. I'm still within time, Lord, in terms of the 2028.
Yes. The present appeal.
But now you
The present appeal has been preferred, challenging orders dated 25th February 2025 and 27th February 2025, passed in the writ petition being WPA 98 of 2021, which was preferred by the appellant, inter alia challenging inter alia. Where is your writ petition? You said
Copy of the writ petition 47A, my lord, of the stay application, P10 connection.
challenging inter alia. An order dated 15 February 2025, passed by the respondent number 3. Stop. In connection with the appeal, challenging inter alia and order dated passed by the respondent number 3. Records reveal that the writ petition was initially heard by the learned single judge on 25th February 2025, and records were called for, and the matter was fixed for further consideration on 27th February. On the said date, the appellant's prayer for interim order was refused. On the said date, the learned single judge did not pass any interim order and directed the parties to exchange their affidavits with liberty to mention for final hearing. Mr. Jaipal and the advocate appearing for the appellant submits that by an order dated 27 September 2024, passed in an order, passed in a writ petition preferred by the private respondent number
4.
private respondent number 4. The court directed the respondent number 3 hearing to dispose of the representation of the appellant. As in the midst thereof, the private respondent was evicted. He was evicted.
He was evicted, Manoj.
Evicted. He preferred an appeal being MAP 62 of 2024, seeking status quo ante. ANT. The said appeal was, however, disposed of by an order dated 7th November 2024, directing the respondent number 3 to remove the unauthorized encroachment and demolish construction thereon after due process of law. Mr. Jaipal submits that in spite of such direction, the respondent number 3 passed the impugned order, being oblivious of the provisions of Rule 202, bracket A, bracket A 7 and 8. In as though a notice was a notice of intent to institute a suit was issued by the appellant on 3rd of March 2020. Such arguments advanced were glossed over by the learned single judge, and the interim order was refused. Mr. Prashant, learned advocate appearing for the private respondent number
4.
submits that the appellant has approached this court with unclean hands, suppressing the fact that the hearing before the respondent number 3 was preponed and a fresh notice was served. In view thereof, the learned single judge refused to exercise discretion in favor of the petitioner, in favor of the appellant, rightly refused discretion. Mr. Sabita, learned advocate appearing for the respondent number 3.
2 and 3, my lord.
Next one, drawing our attention to an order dated 19 February 2025, passed in a contempt application Miss learned advocate appearing for the respondent numbers 2 and 3 submits that the said respondents have been asked to file a compliance report. File a compliance report on the returnable date, that is 7th March 2025. She further submits that the she further submits she further submits that the order dated 15 February 25 was passed in compliance of the earlier order of the Honorable Division Bench dated 7th November 2020. Records reveal that the interim prayer was refused. That records reveal that no interim order was passed when the matter last appeared before the learned single judge on 27th February 2020. Upon obtaining certified copy of the same, the appeal was filed with the leave of this court on 4th March 2025. In the midst thereof, in the midst thereof, the circuit bench, what is that? What you say that circuit bench interval? What do you say?
Lord, because I was, as a lawyer, Lordship, for the petitioner, I completed my last day of the circuit. Immediately yesterday I came, Lordship.
In the midst thereof, the last date of the circuit was
3rd March 2020.
3rd March 2020. 3rd March 2025. The order dated 27th. The order dated, the order dated 7th November 2024 was passed by coordinate bench with a categoric direction that the respondent number 3 shall remove the unauthorized encroachment and demolish construction thereon after due process of law. After due process of law. The grievance that the order was passed without due process of law had been ventilated through the present appeal. Filed on 4th March 2025. However, such grievance needs to be considered by the circuit bench, which would reassemble on
10th of March 2020.
By the circuit bench on 10th of March 2025. Stop. The in the would be reassemble on 10th of March 2025. Stop. The order in contempt was also passed. The order in contempt, in the contempt application, the appellant herein was not a party. And the entire sequence of, and as such, he was not in a position to bring the entire sequence of facts for consideration before the coordinate bench. In the said conspectus, stop. coordinate bench. In our opinion, an appellant cannot be rendered remediless, and when when the present appeal has been filed with leave of this court on 4th March, and when and as the and as today the circuit bench is not has and today there is no circuit bench, and the same would reassemble on 10th of March. We are of the 10th of March, we direct that the respondent number 3 shall not take any coercive steps, against the appellant before the matter is heard. Coercive till 13th March 2025. Let the present appeal be placed before the regular circuit bench, which would reassemble on 10th March. No, list the appeal for further consideration on 11th March, after the circuit bench reassembles on 10th of March, and subject to the convenience of the honorable. Sir, ওটা আগেরটা বলে কোয়ার্সিভ স্টেপস till কত তারিখ বলেছো? Till 30.
Records needs to be sent back to Podlar Lordship at once, otherwise because we hardly get
The registry is directed to send back the records to the circuit bench. The registry is directed to transmit the records to the circuit to the learned registrar, circuit bench at Port Blair immediately.
I'm extremely obliged.
My lord, copy of the appeal and stay application may be served upon me. My lord, was not served.
The appellant is directed to serve copies of the stay application along with the memorandum of appeal upon Miss Shobita.
My lord, I have received the copy, my lord.
Oh, upon Mr. Prashant. Upon
Mr. Prashant and Ms. Das.
no, only page.
Oh, fine.
You have got it.
Yes, my lord, I have received the copy.
Directed to serve the copy of the the memorandum of appeal and the stay application upon Mr. Prashant, learned advocate. Positively within 7th March 2020.
Obliged.
May I get urgent server copy, Lordship, for strict compliance?
But you will get it. We have to rise and
I
sign
understand,
off.
Lordship.
So
Can I get by tomorrow, Lordship?
certainly by
tomorrow
evening it will be uploaded.
My lord, I'm grateful. I'm deeply obliged. I'm grateful.
Obliged.
And any problem of uploading, you come and tell us.
My lord,
Who is your junior?
He's with me, Lord. I'm grateful.
It will be uploaded in the evening.
I'm deeply obliged. I'll take leave. I'm grateful.
Obliged.
Obliged.
But I am for the petition.
তুমি দেবদূতি এদিকে চলে এসো। মানে এইবার এসব কোনো ইয়ে নেই।
দেখো স্টেটাস কো এন্ট্রি সেটা রিফিউজ বিশেষ করে বললো যে ওই অর্ডারটা তুমি এন্ট্রি তাই তো অ্যাডিং দি আইটেম নাম্বার এবং যদি দরকার হয় you may adopt. Here for the statements.
appear for the statement.
Delay.
Yes, my lord, my submission is that, my lord, tribunal.
Give us
Yes,
2 minutes.
yes, my lord.
এই ওটা কে নিল রূপম নিল একটু ওটা তাড়াতাড়ি করে আমাকে একটা সময় পাঠিয়ে দাও। কার্তিকে একটু বলে দিই অভিজিৎ ওই কালকে
To kindly go to 181, where the appellate authority specifically stated the BLRO has wrong in every order sheet. 7 mutation cases there, and specific order is there, and fresh proceeding is initiated by the BLRO. So that should be disposed of immediately. But by tribunal dragging the case for a long till September, that should not be, my lord.
Now, dragging the case meaning you have said that I will file.
Well, if no, my lord, if you, I said before the tribunal, my lord, immediately you also dispose of the application. But tribunal, no, I have, we have no time. আমরা সময় নেব, আমাদের অত সময় নেই। তো আমি তখন if you
dispose of which application?
dispose of the original application instantly, as because
That is not your original application, it is their original.
in my submission, my lord, I have submitted that, my lord, today your lordship, your tribunal can dispose of this application as the specific order of the DLRO is there, appellate authority is there, and the wrong of the BLRO is the annexure is itself. The number of the instrument has not been properly made, and immediately for that.
So appellate authority order was in your favor.
No, but that should not be. Yes, my lord, that has been
favor which has been
appraised
challenged
proceeding.
by us.
If you lordship kindly see 181 page,
Page
181, kindly see. First 182, 181 first. In middle portion, the mutation case number salsa has been disposed of on the basis of registered deed.
Where you are reading?
My middle portion of the page 81, order of the appellate authority.
Appellate page 81, it is not there.
181, my lord, 181.
আরে 181 আমার নেই তো মুশকিল
Order of the appellate authority.
How many numbers do you give to your pages?
That was the annex in tribunal, that then that has become before your
As
lordship.
many numbers you give you
Well, order of the appellate authority, my lord, just kindly see.
হ্যাঁ কি হয়েছে? Yes, এই যে mutation.
Yes,
You
mutation.
are wanting mutation has been prayed for by whom?
Mutation has been paid for by the private respondent.
Your
But-
clients.
My lord, without giving me an opportunity of hearing by the BLRO, mutation 7 mutation proceeding has been done, and
Mutation was applied for by whom? By him.
by them
So BLRO allowed such mutation.
allowed such mutation.
You preferred statutory
They preferred
appeal.
the appeal.
Then what did the appellate authority say?
Appellate authority said, my lord, in this paragraph,
It has been sent back on remand to BLR.
to BLRO for afresh hearing, as because, my lord, BLRO in the instrument, you have to kindly see the order sheet, the mutation case, my lord, there is no instrument executed the recorded riot. You have to kindly go through the order sheet of the appellate authority. And I have submitting the order of the BLRO, where is wrong of the BLRO.
So that has to be considered by the tribunal.
Yes, my lord. And being agreed by this
Okay,
order, we have
before
come
the
up.
tribunal considers, how can you come before us?
But as because, my lord, if your lordships kindly see page, my lord, 21, 27, 30 and 33, where, my lord, BLRO's wrong is
So very good, sir. He has called for the records.
Yes.
He will consider that.
Yes, my lord.
Actually, mutation case was filed based on certain
document
use of partition.
Partition.
That is of partition.
partition. That
But from the order of the appellate authority, it is appearing that during the time of hearing, the sum of the registered deed had not been produced.
Yes.
Yet the BLR proceeded.
Now, my lord, what
It is-
happened?
So whether this thing is not sufficient enough to stay the order of the
no, my lord, you have to kindly see the order in the order of the DLRO. In the every proceeding, you have
My
to
lord,
kindly
my
see
learned-
middle. I'm done, please.
Sorry, bolo.
Mutation cases, my lord, last paragraph.
and hence the sent remand.
Yes.
What interim order you prayed for?
My lord, I am submitting, my lord, before your lordships, my lord.
They have prayed for an interim order that if the appellate order is implemented, my application will become infructuous. So till such date, ask the BLRO not to consider it. Your defense has not been destroyed. Now you are saying that this remand was wrong. That is why the court has called for records. And you yourself has said that, yes, I will use an affidavit to the same. Kindly come to internet
Yes,
page
my lord,
2
my,
of the order.
if you're at the time of argument, my lord, the learned tribunal stated me, well, if today I have not disposing the matter, if your lordship, then, my lord, I have submitting, if your lordship desire, I shall file opposition. But, man, that the fresh proceeding is stayed on till September.
The submission which you are making, tribunal said, আজকে সময় নেই শুনবো না. Why should we take note of in sitting in judicial review?
So that
Then
should
take up the hall with the
no,
tribunal.
my lord, my submission is that original application.
This general statement should usually not be made.
Man-
Suppose you say something to us. It happens in innumerous matters. When we are dictating the order, maybe a line we are missing out. You say that, my lord, add this line in my submission. I will not add it. Now the tribunal has called for records, fixed it for hearing. What is the grievance?
my
You are saying
Yes.
you are in fact challenging the interim order which has been granted to him. This is your grievance. Is this your grievance that you are aggrieved by the interim order?
Yes, ma'am. I have stated my opposition, my lord. In my grounds, I have stated so, my lord.
Your application is in fact for expeditious disposal.
Yes. Nothing else.
Your
If your lordship
application
desire-
is in fact for expeditious year. Don't set it on September.
Grateful, matter. You have to kindly fix the matter in before 2 or 3 months.
We will make the observation. You file an application for preponement. We will make that observation.
Grateful, matter.
He will say. Mr. No, okay. Set aside the
During hearing,
present appeal. The
Grateful.
I am for the
Acha,
petition.
Mr. Nondi, we passed an order in your matter against you. So
Compassionate.
can you give the citation of that judgment?
Compassionate appointment.
I think it is
Amit
reported.
Jha.
Huh?
The name of the petitioner was
Can you
Amit Jha.
give the number and the date
Yes,
of
yes.
the order
Yes,
to
yes,
my
sir.
court officer? You need not bring out any copy. I shall bring it up
Certainly, my lord.
at any time in course of tomorrow.
In course of-
Yes.
I'm for the petitioner, ma'am.
I have appeared on behalf of 9, 11, 12, and 13.
এতজনের হয়ে
9, 11, 12,
9, 11, 12, 13.
All
4
are
persons.
substituted, my lord. My only grievance is the matter is continuing since 2015. In spite of repeated heading for hearing, the matter is not been taken up.
Affidavits completed.
My lord,
Affidavits completed.
my lord,
Affidavits before the tribunal.
I have already served affidavit. I have served affidavit. It is already completed, but gone to the video service in the department, my lord.
We are not saying that. Have you used
ট্রাইব্যুনাল অ্যাফিডেভিট কি কনসিডার হয়েছে
হ্যাঁ,
pleadings exchanged?
লেডিস আছে
Yes,
Pleadings exchanged before the tribunal.
my lord.
Nobody
Yes,
did.
yes. I'm hard of hearing some sorts of my lord. Some sorts of hard of hearing. My lord.
There are procedural irregularities in the application. Because of the fact, my lord, that respondent number 6 has died. But you also kindly see the successor, legally certificate. Your Lordship.
What is your problem?
There is no my problem. Is the procedural irregularity is there. Wife was not made party to
No
the
proceeding.
proceeding.
That you take that ground before the tribunal.
It is substitution.
What was the matter about?
Actually, it is a correction of the record of right on the basis of a civil court's order. I got the civil court's order lost, but I have collected the information from the record sections of the collectorate and submitted it, but neither the BLRO nor the appellate authority admitted it. That is the contention of the my
So
petition.
you are not being able to produce the document as regards your title.
Exactly, but secondary events I have submitted. But
Come
first
to
evidence,
page 82.
my lord,
Come to page 82.
page 82.
The appellate authority says, from the observations made, it is clear that Sahadev Board and others, you are Sahadev, was unable to produce the document proving title.
Yes, sir.
In this case, the copy of the order of JMIS case number 10 of 1961.
61.
Lower court decided the matter is before the. So after that, you obtained the copy.
I could not collect the copy from the department, neither from the record section. After that, we collected a copy from the collectorate that whether this suit was actually disposed of in favor of me or not. That was what I have collected. Kindly have a look. Information slip.
1961 case.
Yes, my lord. Kindly, this is a government document. Can they deny? Page 39. Page 36 and 37.
In
36 and 37.
39.
36 and 37. I have collected this information from the record section of the government.
Information page. Shukdev Palika
dismissed on notice with cause of regular.
What is the information? What is the information?
My lord,
Dismissed
It
on
was-
whether it is dismissed.
Uh-huh.
The preemption case that is judicial miscase was dismissed.
Where do we find it?
My lord.
Where do we
Page
find
37,
it?
Your Lordship kindly comes to page 37, my lord. Dismissed on contest with cost. The order of the learned Munsif granting preemption is hereby affirmed. Records fee is assessed rupees so and so.
So this order you could not produce
I
before
could not
appellate
produce,
authority.
actually, my client could not keep
So
that
when
all.
did you get this order?
But this order I get
is
from
of
the record
63.
Yes, my lord, from the record sections of the collectorate. The public
You
document.
got it when? 63 disposed of. You got it when?
To 2008
Our world 2000.
compared to
So you did not apply for certified copy of this order?
my lord.
Certified
Page
copy order.
38.
I made separate copy of the order.
কোথায় পাবো?
it-
They applied, they have got. Page 38, you see. Order was passed on 6th April. They applied for certified copy on 20th April.
It is not applicable. It is not,
1963.
yes, ma'am. But it is not available in the record section.
After 12 years, it will be destroyed.
It is, but that's why this information was collected. That's why this information was collected. Whether this information is valid or not, that is the question before the
Where
planet
from
time.
did you get this copy?
My lord,
Where from did you get page 38?
it is collected from the
কোথায় লিখেছেন? Where do you state?
record section, my lord.
Hearing.
There কোথায় লিখেছি?
Early hearing চলছে। June মাসে fixed। মাসে fixed করতে
The present writ petition has been preferred.
Of early hearing.
Everyone was substituted.
Pleadings you have completed before the tribunal?
No.
Then why did you say?
My lord, tribunal, tribunal.
Tell us whether any.
I am coming to
Whether
the
the original application is ready for hearing.
kindly have a look on
Forward.
page 86, the order of the honorable court, where the substitution was allowed.
We are asking one thing, you are saying anything.
Forget
I have-
about substitution.
I have made an application.
We are asking second question, whether the matter is ready for hearing.
Ready for hearing.
After exchange of affidavit by the
Everything is complete.
He is saying that no.
Everything is complete. But he is wrongly saying.
Those who are trying to
Why
say they
the-
are not executed.
Kindly have a look.
How the matter?
My lord, they are trying to drag the matter. Drag the matter. Taking the advantage of the.
আর কি করে রেখেছে জানি না।
All of that is statement you are claiming substitution done, he is claiming no. You are
I'm-
telling that the affidavit, that is reply rejoinder, already complete.
Completed,
Huh?
completed.
He is saying no.
Kindly have a look on the
Acha, we will give you liberty to go and file a preponement
Preponement
application.
application.
one.
If you have
We will
matter
make
one-
the observations.
1 minute, my lord. Kindly have a look on the impugned order. First impugned order, 24th April 2000.
when you have filed seeking
The
direction.
one MA application was filed, but the matter was kept for hearing of the MA and as well as the hearing. That is our question. How can it be? MA should be disposed of first, then the hearing matter.
What was the MA for?
MA for supposed to correction of the prior portion, some prior portions.
So what is the
Amendment,
problem?
amendment application.
For substitution.
And
No,
the-
no.
and
Why
the-
you are making several-
this order was passed on 24th of April.
Yes,
And you have come before us after how many months? নিজে 10 মাস দেরি করে এসছে এখন বলছে এক্ষুনি শেষ করবে
no, my lord.
What no, my lord?
I'm not telling that. I'm not telling that. But they have put the matter, kindly have a look. Learned counsel for the applicant submits that he has filed an application being MA number auto. Let the application tagged with the OA. The matter stand adjourned, the matter appear in the list under heading hearing.
So what is your problem?
My problem is, two matter cannot be heard.
Who told you?
My
Who
lord,
told you? When an application for
in
addition
the
of the-
tribunal, there is a system. When MA is filed, it is heard one day, and after that hearing matter will be fixed. My lord, I'm praying only one thing. Let the two matters be had in 2 days, and my hearing be completed within the period, my lord.
you make an application to the tribunal, we will give you that leave and pray for
My lord,
preponement of the hearing.
subsequent, let the subsequent order. Kindly have a look on that subsequent order.
What is the subsequent order?
It is for hearing. It is for hearing, but where the MA application gone?
What was your MA application?
My prayer is very simple.
MA application for what?
MA for amendment of the prayer. Some
Show us that MA application.
I'm not annexed here. Right now. I can let it be fixed on.
You file application. And you bring this back to the notice of.
What application shall I
You
file?
bring this back to the notice of the tribunal. No tribunal or court keeping one application pending will not dispose of the main petition.
Exactly, my lord. I'm
Okay.
telling that.
You bring this back, tribunal will take care.
My
of
lord,
this.
this
Okay.
illegal
For early disposal, you have come.
illegal order is passed by the tribunal. That's why I'm coming before you, your lord.
Where you have challenged? Where you have challenged that this order is effectively set aside? Who was this prayer?
Kindly, let my prayer be
Okay, let your prayer. It
Page
is
18.
allowed.
page 18. Guys.
Thing which you are submitting is contrary
To
to what
fix an early date, my prayer is
Uh-huh.
to fix a early
No,
date
no,
for
no, no.
disposal of the
Fix-
amendment application.
read
Being
madam
MA number
as-
auto,
Huh,
as well as original application pending
huh.
since 2023, complying the provision of section 10(5).
Yes.
Within 10(5), there is a provision within 6 months, the matter will be disposed of. When a matter is filed in the year 2015,
The administrative tribunal acted out.
No. Land reform. Land reform.
ওকে মানে কি মানে আমাদের
Electricity.
ডিলে
হ্যাঁ।
করতে
Land reform সে পিছনে যদি থাকে আর আছে কিনা? না।
10(5) kind of.
Show us the rule.
Hello?
Show us the rule 10(5).
I'm not brought it.
You're doing a matter, you will not.
Mandatory. It is mandatory, my lord.
Where is it?
বইটা আনাই আমি।
Follow করছে।
No, it is an application under section 6. Under section 6 মানে main application. Under
Yes, main
section-
application.
Huh?
Main application.
Huh? Jurisdiction under section 6 is main application. Where is the provision that
My lord,
application is
my
to
lord,
be decided?
allow me one day. My lord, allow me one day.
No one day. You have an show that where is the provision that application is to be decided first,
I've
and it
I've
cannot
not, I've not come with a group. I said so, my lord.
Then you should have said that at the first.
You made an application.
Make an application before the tribunal for preponement of the date of hearing. We will record matter is pending since
It is
2000.
direction, my lord. 2 matters we had actually.
Ashok, the present,
That is my prayer.
the present writ petition has been preferred. Has been preferred
This matter, my lord, I beg to appear on behalf of the petitioner. I have served the copy of the writ petition sent, my lord. I have sent it on 27th.
2 weeks.
Mal-
Yes.
My lord,
2 weeks.
2 weeks.
Complete service.
My lord, this is the my lord, peculiar case. Two of the members.
It has to be
My-
peculiar
my-
because you are appearing.
2 weeks.
Yes, court.
I am appearing on behalf of the private respondent. Yesterday, my lord, I have received the brief.
Here is the affidavit service.
Keep it with you on the
Next day.
My lord, Friday, my lord.
Friday.
Yes. Yes.
What expeditious disposal?
No, no, no.
No, my lord. No. What happened, my lord?
আচ্ছা ঠিক আছে ফ্রাইডে শুনুন ফ্রাইডে ইয়েস নেক্সট
Five in my
My lord, Mr. Somu Mojumdar is appearing in this matter. My lord, I'm praying for not today, my lord. He's kindly engaging.
I asked my learned friend. He just told me Mr. Munja wants to do the matter. I waited for this.
My lord, I bow down to your lordship, my
নেক্সট
lord.
থার্সডে
My lord, he is engaged in court number
আরে
13.
স্যার উই আর কিপিং
Thursday
ইট
রাখতে
নেক্সট
তো।
থার্সডে
My lord.
and ask Mr. Mujumdar to fight it
Malada.
out with Mr. বন্দ্যোপাধ্যায়
Malada.
ভালো করে মাত্র
Well, he first told Mr. Munja won't do the matter. I
Yes,
said,
next.
Malada, maybe on 18th or thereafter, my learned junior has some difficulty on Thursday. Malada, assisting me. Malada.
কি ডিফিকাল্টি বিয়ে কোনো
newly married. We can remember.
18th
But he
After
18.
Any date after 18.
এরকম করেন না যত
the 24th এ রেখে দাও
Grateful.
yes next
তুই তো বললি করবি
না না একটা অর্ডার করে দাও on joint prayer of the parties comma the matter stands adjourned establish the matter for further consideration on 24th
Grateful.
এক্সেপশনের একটা স্ক্যান কপি আছে না আপনার
আমি স্ক্যান করে দিচ্ছি।
joint prayer করে দাও
No, sir, you have.
এই দাঁড়াও
Yeah.
wait Heard Mr. Bandyopadhyay, learned advocate appearing for the petitioners. Stop. Today, however, today an adjournment has been prayed for on behalf of the respondents.
My lord, read petitioner respondents.
In view thereof, list the matter for further consideration on
4th.
Yes, next.
Grateful.
The respondent, man.
Respondent,
Statements.
who is for the petitioner?
Petition.
Wait.
My senior is on the way.
Acha, wait. Did we hear it earlier?
No, man. That has not been heard.
We take it
Limitation
up on
petition is there,
Tuesday.
man.
হয়েছে? All right, we take it up on Tuesday, madam.
Lordship, kindly grant me a short passover, Lordship. My senior is on the way, Lordship. Please,
Pass over the.
please, Lordship. Grateful, Lordship.
Seven, my lord, I am for the respondents, with petitioners respondents.
Which for other side.
Tonoy Chakraborty is appearing for the state respondent. The state
24th করে দিচ্ছি।
20. Grateful.
No one appears on behalf of the petitioners, though no one appears on behalf of the appellants. This is of their lordship's determination.
No. This is your lordship.
So the learned advocate appearing for the respondents is present. In view thereof, list the matter for further consideration on 24th. Yes, next.
Number 8.
But I appear for the respondent numbers 1 and 2.
Item number 8, Mr. Aniruddha Chatterjee is appearing for the appellant, your lordship. I have tried to inquire where he is, but I couldn't, your lordship. It could be a.
Next
They did not
Tuesday.
appear, my lord.
Achha, Mr. Lordship.
Next Tuesday.
Next Tuesday.
What are the number?
Next Tuesday.
তাহলে কবে not
I want it. I was very confident.
It will be on 17th then. 17th.
One day later.
Yes.
One day later, my lord, kindly, my lord. 12 to 17 will something.
I am for the respondent.
My lord, item number 9 to 11. My lord, I make the appeal for the petitioner. My lord, I'm being led by Mr. Sakanshu Basu. My lord, he's on his way. My lord, may I file the affidavit of services?
Yes.
9 to 11.
Item number 9.
9, 10, 11.
My lord, it's any day, my lord, next week, my lord.
Which one?
Item number 9.
8.
8, I'm sorry.
18
বাইরে 9 দেখাচ্ছে
9.
হ্যাঁ
আমাদের 8
You are in which matter?
I'm sorry, my lord. I thought I was at 9, my lord. Actually, I was an 8.
What we have done in 8? What?
18.
On 18.
18th we have.
No, Mr. Chatterjee was wondering whether my lords would pass an order today on the fixing it on
Because he gets an advantage, not me. I'm appearing only for the state.
18 তারিখটা কি হলো?
If your lordship can, we were just wondering, my lord, for some of us.
নিয়ে নাও
Obliged to not deeply.
8 নম্বরটা দেখিয়ে দাও।
So grateful, my lord.
Other learned advocate asking for the respective parties to leave the matter for further consideration on 18th.
So grateful, my lord. So great.
My lord, deeply obliged, your lordship.
You are obliged to only one member of the bench.
No, my lord, deeply obliged to your lordships, my lord.
Oh,
I said
He said lordship, my lord. I heard, my lord. Lordship.
তুমি এসো কি
হ্যাঁ যাও এসো যাও my lord, he is an anti Rohit Sharma man.
Come.
হ্যাঁ যাও
I shall be there, no change of determinant. Yes, next.
নামগুলো নিন হ্যাঁ এই নাম দিয়ে বাবা ডেকে দে তো
Yes, Mr. Basu.
Section 5. Only 7 years delay. 7.5.
আর একটু করে আসতে পারছেন?
7 বছরের পর আবার কিছু দিন আছে।
কি বলছো? Opposition? আচ্ছা, heard Mr. Basu, learned advocate appearing for the learned senior advocate appearing for the
Lord, if you Lord, he had the grounds, my lord, I don't think he has a right. I am not disputing that. If you Lord, he had the grounds, I think no affidavit may be necessary.
So he says he will file an affidavit. What?
That I know. পরের দিন আলাদা হবে কি আছে?
Mr. Mahato, learned advocate appearing for the respondent numbers. Private respondent.
All respondents.
He's a lead petitioner. Lead petitioner. There's a leave to appeal. Only outside.
Is for leave to file an affidavit in opposition to the condonation application filed in connection with the appeal. Such
The leave to appeal.
No, unless my lord, your condonation is there, leave to appeal. Yes, I am the outsider. That's why I say.
Oh.
So
if leave to appeal is considered,
that's why I am saying, my lord,
limitation will আসবে জবে থেকে জেনেছে তো জবে থেকে জেনেছে 7 বছরের দিলে তো
আগে তো লিভটা করতে হবে আগে না ইয়েটা
after the order was passed, the authority entered into an agreement with me, suppressing that there was an order passed by your lordship's court. When one part possession has been given, when I inquire for the other part to give possession, then they say that there is an order.
Two application. Now leave to appeal would be decided first or section 5.
Leave to appeal. Leave to appeal.
First, your right to be determined.
Right. That I'm saying. Leave to appeal.
First, leave to appeal.
Then if I cross that, then
if we
appeal.
say that you are
entitled to prefer an appeal, then question of limitation comes.
Limitation will come.
Then leave to appeal may be allowed, but section 5 I shall file affidavit. Leave to appeal allowed, no problem. Then my lord, I am.
Upon hearing the learned advocates appearing for the respective parties and considering the averments made in the application seeking leave seeking ওটা ক্যান নাম্বার কত নাম্বার ফাইলটা একটু দাও তো
Prefer the proposal. একটু জায়গা ছাড়া
Upon hearing the learned advocates appearing for the respective parties and considering the grounds stated in the application being can 1 of 2024, we grant leave to the appellant. We grant leave to the appellant to prefer the present application. The said application being can 1 of 2024 is accordingly disposed.
There are three matters, my lord. There are three.
আবার কোথায়?
9, 10, 11.
তাহলে 9, 10, 11
Can
separate
do-
order হবে।
দেখে বল না বাবা একটু
9, 10 and 11 all
Can
leave to
two-
appeal.
can two is the leave to appeal.
No, can in item number 10 it is can 1,
Can two.
আবার বলে 6। এটা item number
9 হলো। I'll take it separately, otherwise it will be me.
9 এ তো can 1 is seeking leave to appeal।
Can 1, হ্যাঁ।
9 এ
আপনার হাতে কি দেখলেন?
আমরাই দেবো। কি লেগে upon hearing the learned advocate considering the grounds কি বলেছে?
হাতে রয়েছে তো।
Grounds taken in the application can এত we grant leave to the appellant to prefer appeal against the order appellant to prefer the present appeal. The said application is accordingly disposed of. Stop. The respondents pray for leave to file an application to the application for condonation of delay. Being can to file an affidavit in opposition to the application for condonation of delay being can 2 of 24. Such prayer is considered and allowed. Let such affidavit in opposition be filed within
4 weeks, ma'am.
4 weeks. Within 3 weeks from date, reply thereto, if any, be filed within 2 weeks thereafter.
1 week.
The parties would be at liberty to mention the matter for further hearing after expiry of the period as fixed above towards exchange of evidence. এই সেম অর্ডারটা ওইগুলোতেও করে দিও ওনাদের নাম।
From the date
একটু
of
নাম্বারটা
knowledge,
দেখে নেবেন। নাম্বারটা একটু দেখে নেবেন।
নাম্বারটা একটু দেখে নিন।
from the date of knowledge, you will say.
That I have stated. A peculiar thing. 9 crores I have paid. When agreement executed, then also it does not disclose that there is an order passed by Lordship's court quashing the acquisition
So
proceeding.
that you can appear as a senior counsel in this matter.
Here.
সেই জন্যই তো বলি সপ্তাংশু বাবু আর কি।
My lord, one day
You
just
should thank him.
outside, not here. তিনটেই করে দেবে না দেখে একটু করে দিন।
Yes, next.
Grateful.
My lord, there was a Passover matter. Can it be taken up?
কোথায়
My
গেল
other
password?
side is there. My
কোথায়
lord.
গেছে password? কোনটা password?
Item number 6, my lord.
Your other side is here.
Other side
চলো
is-
ডাকো password 6.
My lord, on the last occasion, there was this appeal was restored with its original number as it was dismissed for default earlier. Now, Lordship, there is a delay of 165 days. 165 days in
You're
preparing
opposing?
this appeal.
No, I am not opposite.
You're for the respondent.
I'm for the state respondent.
State respondent. Item number 6.
6, my lord.
Any private respondent is
My
there?
lord, there is no private respondent. My lord, the petitioners were engaged in as an apprentice under Department of Motor Vehicles, Government of West Bengal. My lord, kindly come to the impugned order. Impugned order was passed that petitioners were engaged through the private agency, Many JS Transport and Traffic Training Institute and Management Society, as motor vehicle inspector to work with the transport department on the state and on contractual basis with specific conditions.
So your writ petition was disposed of
My lord, it was disposed of.
without granting any relief to you, but observing that, sir. So it has to be hard.
Hard.
So no question of issuance of any interim.
Right now, Lordship, we are disengaged. We are not there in service, Lordship.
Oh, you are yes. So there is no scope of any
Scope of passing an interim order, there is no scope.
The present appeal has been preferred. Challenging
And for the respondent, my lord.
Or in this matter, I am for the appellant, my lord, led by Yusuf, my lord. Due to his illness, he did not come to the court, my lord. I'm praying for accommodation for the day. My lord, there is a delay of 40 days.
Taken, but compensation has not been paid since above 25 years. But in spite of that, Lordship, taking this time, Lordship, only my prayer, Lordship, kindly fix this day, Lordship, to fix this day, Lordship.
No. Are you opposing the section 5?
Yes, Lordship, I am opposing, Lordship.
Opposing the section
Let him to file affidavit, my lord.
Lordship,
that will be beneficial to you. More delay will be committed.
There is a 444 days delay, my lord.
delay, but Lordship, kindly see the ground on which the petitioner appellant prays for.
We will consider you use an opposition to the same.
Lordship, if your Lordship kindly allow me, Lordship, I will submit. Lordship, kindly see page number, Lordship.
First tell us whether you will file the opposition or contest the matter. Then we will fix the date.
Lordship, I will file opposition, but only Lordship, I will take Lordship 5 minute time. Lordship, kindly see
File
page number.
Lord, my leader, Mr. Yusuf, did not come to the court, my lord. I am praying for
Because the
accommodation.
ground on which the appellant pray for condone the delay, which is not maintainable.
To bring that on record by file an affidavit.
The
present appeal has been preferred. কি বলবো? কি শুনে নেবে?
Section 5 এ তো একটা affidavit জল চাইছেন তো।
কি বলছে? File an
Para number 3 and 4, Lordship, if your Lordship kindly sees the para number 3 and 4.
What order was passed?
An order was passed, Lordship, by directing the respondent authority to take necessary action to provide the compensation to the petitioner. Because
File an affidavit stating devolution of right in respect of the land or portion.
A connected matter has, in a connected matter, the state has not, this is with regard to not mining lease or quarry of sand.
Who is your other side?
State.
First
Not-
time it has come.
not in a similar matter, state has preferred an appeal in a matter where the court has passed an interim order in my favor.
Similar matter.
But in respect of another plot of area of land, but the court had granted not an order in my favor, by which not a reallotment was allowed in my favor. This has been taken up in appeal before the division bench by the state. Now, not in my case, in this pertains to a different plot of land. Interim order has been refused, for which I have come up in appeal. Now, not the fate of that appeal will also decide the fate of this case. But the stand of the state in that appeal is.
Have you served, Mr.
Yes, service is complete.
Ascertain and come back who is for the state?
And Mr. Siddiqui appeared in that appeal.
He was here. Huh? Siddiqui, Mr. Siddiqui. Give him an intimation and come back on 20th.
And maybe also indicate the number of the other appeals so that both may come up tomorrow. I mean, together.
Why other appeal?
That the state has preferred an appeal on the ground that this reallotment cannot be made
You
by
are
them.
appearing, Mr. Siddiqui. Did you appear in the earlier appeal also?
Another appeal has been preferred by the state.
Ascertain from Mr. Mojumdar and come back on 20th. Yes. Next. No, বলছি না। 14 কে আছে? দাও একটু ফাইলটা।
Well, at 14, I'm for the state respondents. Last occasion also probably the appellant was not here.
Dismiss. This is encroachment for PWD land.
My lord.
Decision was directed to be taken.
My lord. Against that appeal has been preferred.
So records reveal that no one appeared on behalf.
In this matter, I am appearing for the appellant petitioner. My lord, my lord, this present appeal is preferred against the order dated 24th of January 2025. My lord, thereafter, my lord, where the interim order was, my lord, which was continuing since 2021, that was refused to be extended. That is the crux of the appeal, order under appeal. Today is the date fixed before the court below. I mean before the learned single judge regarding the my application for extension of interim order as well as for addition of party. My lord, kindly make it not today so that I can come back after fate of the matter today.
Addition of party.
My lord, initially, my lord, initially
has not taken out a leave to appeal application. He is not a party to the writ petition. He has taken out an application seeking addition. In my writ petition, there is no interim order, apparently. The order of 20, if he is carrying an appeal, first of all, he has not served on me. 24th January 2025 order records my presence, my instructing advocate's presence. Mr. Dotto was there also, not in the matter. Now, my lord, incidentally, on the 24th of January, my lord, it appears that they had taken out a can 2 seeking addition in the writ petition, claiming some right. Now, my lord, that can 2 was apparently not served on me, and therefore the matter was adjourned. The
It was
applicant
well
directed
served.
serve can 2 as well as supplementary affidavit upon all the respondents and file affidavit of service. Let the matter appear on 21st of February.
It
On
was
the
served. Well, I'll come back tomorrow.
on the 21st of February, this is the order.
Let me make it not today. It's a property where the writ petitioner is.
First you have to be added, na?
That is why my leave to file appeal is there before your lordship. Person
Leave to appeal, there is no cause to file leave to appeal because you are not a party.
I am the petition. I am an application which is to be considered, which was taken on board. Affidavits are directed to be exchanged. But the writ petition, which was the interim order, which was in there by the Honorable Appellate Court.
So
It's not so, my lord, may I?
The issue whether you are a proper party or necessary party.
That is to be decided in my application.
Is pending consideration before the learned single bench.
My lord.
That has not been decided.
Not been decided by the
Yet
property.
you have
By the property is in jeopardy.
Can come if you have you filed any application for leave to appeal.
Yes, my lord.
Huh?
Yes, my lord. Can one.
So how at this stage it can be maintained?
My lord, at this stage it is maintainable because the property in question is in jeopardy, which is my lord, interim order by this honorable court division bench. I am under
Yes,
protection.
if we grant leave to appeal, that means we recognize your right to intervene in the
That is
matter.
why, my lord, I am praying
Then
for
now
not
what
today,
will
my
be
lord.
the application for addition of party?
Absolutely, my lord. In that case, I am praying for only not today, so that the fate of my application before the learned single judge can be decided by today 2 p.m.
So why did you bring it in the list?
Yes.
Why did you give the returnable date to?
My lord, it is my property, my lord.
You have mentioned.
It is not even his property.
My lord, no, it is my property, my lord.
SAPI has
It is my property. But if they have any cause of action, they can file a suit.
If you unnecessarily continue without
I am
answering
not continuing, my lord. I am
no,
praying
you
for
are
not
not
today only.
answering.
I am
You
praying
are
for
not being fair to this court. Court is putting a question to you.
kindly.
You are unnecessarily questioning as to why the court has asked for an answer to that question.
My lord, I think, my lord, I am being.
This is the problem. You do not understand what you are submitting.
My lord, tell me, my lord. I'm here, my lord, to obey.
We are dealing with 1,000 matters. When a question is put from the court, at least appreciate that there is some substance in such question. What has my brother asked you? That you have filed an application for addition of party. Yet simultaneously, you have filed an application for leave to appeal. Unless the application for addition is allowed, can we consider your prayer for leave to appeal? We cannot.
My submission, may I submit? My submission is that it is not my application to be adjudicated. This is the property where the Honorable High Court is in session of the matter in the entire property. That property is in jeopardy. Even if I am not a party, my lord, it is
An adjournment has been prayed for on behalf of the appellants.
Let him effect service on me.
You withdraw.
I cannot withdraw.
Come apply.
I cannot withdraw. Even if I have not filed any application for it.
And hence it is prematurely. Your leave to appeal.
May I come back? May I come back on returnable date?
Your application seeking leave to appeal.
That is can 1, my lord.
Dismissed on the count of premature.
My lord will decide it. Then my lord can hear it. My lord decides that.
Okay.
Can hear it, my lord.
Okay. Two things cannot be agitated at the same time.
My lord, kindly
You are claiming yourself to be the proper party and necessary party. You have filed an application. That is pending consideration before that.
Pending, my lord.
So two issues cannot be agitated two forum at the same time. Okay.
That is why I am praying for my lord. Only not today, my lord. But kindly make it not today only.
No. Why not today? Adjournment cannot be granted on as per your dictation. You argue on this point.
No, it's not.
It's not. You can make.
It's not so. It's my humble submission.
Again, before an higher forum, appellate forum, you are seeking to leave in the intervene in the matter.
I am assailing leave, my lord.
Then the application for addition of party will be nothing but impact. Because your right to intervene in this matter will be recognized by a appellate forum. though your application for addition of party is
But
pending.
kindly make it not today
That
only.
is, that your consideration to write whether you are into a proper party or necessary party is yet to be determined.
But kindly make it not today, my lord. My lord, kindly make it not today.
You withdraw it and file afresh. If you add it, then you will automatically got a right to appeal. If you not add it, then you will come with an application with leave to appeal. Okay? You argue. Then so you started that, then I shall argue. Okay, you argue.
My lord,
Argue.
is it your lordship?
I am
Serious to make it not today
I am
only.
saying it's your application for leave to appeal is premature since your application for addition of parties pending before the trial forum, before the.
My lord, decide after 1 or 2 days, my lord, make it not today only.
Question is not that you are unnecessarily arguing.
No,
We do not, we can always give you an answer. But your tone and tenor should be such that, my lord, under a misconception, maybe I have filed, but the application will be hard.
I could not make myself
No,
clear.
no,
my lord.
you, how many years of practice you are here? And you are setting up an example for the junior standing behind, that you first contest with the court, even if you have nothing in your matter. This attitude is not proper. You are an advocate. You are an advocate. We respect the advocates. But you people think that whatever I will say to the court is a matter of my right, I will get an answer.
I have. It's my miss.
On the prayer of the learned advocate appearing for the appellants, an adjournment has been today, an adjournment has been sought for
You are there. জীবনে কিছু করুন না একটু খাওয়ান
সই খারাপ করেছে নাম্বার 16
ক কপি আছে 4 কপি আছে so my lord hello it's all right.
Yes.
Now I've just
Oh, that matter.
I've just prepared an account. Now at present the due is 1 crore 57 lakhs. I'm just handing over these accounts.
No, the matter has become infructuous, Mr.
No,
Petition has been taken over.
we have given, not taken over, we have given it in compliance with also.
So we will say that there
Yes.
nothing remains to
No, there is another.
to the trial court.
I appreciate one thing. On the last occasion,
Direction to expeditious.
on the last occasions, as I'm told, I must finally confess because at that time, due to for obvious reasons, I left. For obvious reasons, my lord, I left. Not for antagonize, but for other reasons, serious reasons. Those who are not suffering from minimum sugar, they won't be able
Yes,
to.
argue, Mr.
Now, so my lord wanted to know how much is due or how much is actually not paid. So that's why I prepared a chart. Because now it is all law is very clear. If I correctly say,
Mr. Banerjee, we cannot go into that issue, no?
no, what I'm on,
Your appeal, you have made any prayer that compensation
Is-
direct me payment of compensation? We will
no,
leave
this
that
is
point.
in course of hearing, that point was raised. Question is this.
No, that we raised to justify whether we are in such circumstances we should pass an interim order. That was the ground.
That I've taken the ground. That I've taken in the grounds.
So we wanted to know from you, Mr. Banerjee, how much is due? You said crores of amount is due. We are not on
1 crore 57 lakhs. But once he enjoying the property, after he failed to obtain any order from the court that, well, enhancement is illegal. On the other hand, court found it is totally legal. The
at 72 per square feet. That amount has been declared legal. So now law is clear. If you suffer an order, if you enjoy that, you'll have to pay at the market rate. I have just stated that today's due is 1 crore 57 lakhs. And I'll hand over to them the chart so that they can controvert if they so desire. By
Give it in the writ court. Writ court will.
no, here possession is handed over by your lordships. The law is very clear.
We did not interfere with the order.
At the same time, just a minute. I have not yet finished, my lord.
Yes. No. Yes.
Otherwise, my lord, order which is passed against that, I pay for an appeal. I pay for an appeal. Now, in the appeal, my lord, we wanted that, well, this is something is due. If I'm not wrong, that we have stated.
Yes, I asked you.
Count 3, 4. Count, no, it is also my 3 and 4.
That what was the reason behind taking over possession? Why do you take over possession?
Yes.
In answer to that, you said that they are enjoying on one hand, they are not paying the dues on
And
other.
after expiry of lease long back, lease has expired long back. At the same time, they submitted that, well, I agreed to allow him, provided he paid that enhanced rate. Now, my lord, that rate is about 72. When that was enhanced, they challenged it. Now, very well. Once they have a right to challenge, but they failed to substantiate their case. That means, right from 2018 till today, they are liable.
Then what we will do, Mr. Banerjee? What order you want from us today?
Ask them to payment the money. Because that is
the
also
writ petition is pending and we have allowed.
But that either is petition pending or not, they will have to pay that because their other writ petition failed. Even if the writ petition is allowed.
You're putting the cart before the horse.
No, well, I just cited one example. In Roxy Cinema, my lord, same thing was happened. The cinema hall was locked. Then there's a huge amount of due. When they moved, Justice Deepak Datta, as it was then was, says, yes, I'll ask them to remove the lock. At the same time, the due, what is due, you must pay that. Now, I'm just making a simple pair, subject result. Am I not able to have my money? For the last few years, without paying him money, they're enjoying the property. 1 crore 52 lakhs is due now.
52 lakhs.
57 lakhs. I prepared a chart.
But they are paying the agreed rent.
My lord?
They are going on paying the agreed rent. No.
Let them file an affidavit. Let them file an affidavit. Let them file an affidavit to that effect. Let them file an affidavit to that extent. I don't mind. But how they are enjoying after all with the blessing of the court's order. I have committed it wrong. Mike can committed it wrong. He has been punished. No, you must hand over the possession. That you have done. They cannot deny. But now they are enjoying.
We'll decide that, Mr. Banerjee.
My lord?
Will that be decided by the appeal court or by the writ court who is deciding the writ petition?
No, he filed an application. That is why the restoration was made. Against that, we paper an appeal. This is an offsuit. Main matter is still pending.
Yes, that is.
That's why, my lord, in main matter, that question was not there.
Preferred the appeal being agreed by the directions for handing over possession.
That is on the basis of the application in connection with the main matter, not in the main matter itself.
So main matter is what order? Has the court decided your compensation amount?
That question, well, kindly appreciate. Probably I'm not clear. Let me clear.
Mr. Banerjee, in the order impugned, shows one line that compensation amount not paid has been spoken of by the judge. It has not been done. You were agreed that when I am in possession for justified reasons, how can you overnight throw me out? That's why we entertained the appeal.
Well,
we questioned you that, Mr. Banerjee, what is the reason? Why did you do so? You very fairly submitted that, yes, interim order was subsisting when the possession was taken over. But the reason behind such taking over possession was that, my lord, how long we will wait for our earned benefit? I want that amount. It's a statutory organization. We appreciate that, Mr. Banerjee. But in this appeal, and if we call for an affidavit, this will go to your prejudice. Unnecessarily, the appeal will be kept pending. Because after we consider your submission, we have to pass some order. We can pass one order that pay the compensation, give being possession, do everything. that is during subsistence of the writ petition, that Mr. Banerjee, we cannot do.
This is one way of approach, but correct.
And
Now,
the other approach is
other approach,
that we
let
will
me
say to the, we will request the learned judge, since the appeal was restricted to the consideration of interim order, and we have not got into the merits of the claim, as submitted by Mr. Banerjee, there are crores of amount is pending. All these issues will be decided by the learned.
I don't mind, but at the same time, kindly direct the court below to hear immediately. If it is extended from time to time, 13 times it was extended, but enough is enough. I am not blaming anybody. But question is, if it is extended from every time, it is impossible. Let the main matter be heard with a similar time.
My argument. In the writ court, I have concluded my argument.
Acha, we will say.
And whenever I start, my lord,
Record it.
3 years. 3 years it is pending. He says he has completed argument. I started my argument. Every day they are asking extension.
Yeah, I will not ask for extension.
Of course you can. Of course you can ask.
But so far, my instance, there is no delay. I have concluded.
No, delays means
You catch hold of him outside the court.
Yes.
Mr. Banerjee will.
Mr. Banerjee can hold me. But don't ask Mr. Gupta to.
no, I will not appear with you. Enough is enough. No, enough is enough. Just now my lord told another lawyer. After all, don't forget, you are an advocate of the court.
You have an appointed counselor, Mr. Banerjee.
No, was not.
Very senior. If you, this thing you are saying now, that when Mr. Banerjee is arguing, you are speaking this word now. You are bona fide. But the person, litigants who are sitting behind, they come to know that even if I have engaged a senior, I can jump up and argue. And I tell you one personal experience of mine. In a matter which was being contested before the Chief Justice, I
The time bound, certain time may be fixed. Certain time may be fixed, my lord, so that it can be disposed of. 13 times the extension.
the present appeal Yes. The appeal and the connected application.
Item number 70. My lord, I am for the.
I appear for the respondent's school, the answering response.
Secretary Board, your lordship.
Petitioner is a lady clerk of a school.
At a lady clerk, it is justice standards determination.
My lord, I
তো
mentioned
আমার
it.
কাছে sure.
Deputy, yesterday I mentioned your lordship granted me leave to move it because the school authority have stopped the salary of the petitioner. My lord,
It is money is with you, sir. Give some money.
petitioner, my lord, being a lady clerk, plus she is a mother of 3 months baby.
Yeah, if you give us 2 minutes.
My lord.
Where is that order of 20th December?
Page 68, my lord. Page 68.
Yes. You have not resumed your duty.
Yes, my lord, my lord, I'm coming, my lord. My lord, she has 3 months baby. My lord, after my lord, completion of my lord, maternity leave, she applied first time, my lord, on page 60. My lord, kindly see once.
For maternity leave.
Yes, my lord, আমি বন্দনা দাস, my lord, may I read? আমি বন্দনা দাস ক্লার্ক অফ ভদ্রকালী বিদ্যাপীঠ, আমি 10th June 2024 থেকে 6th December 2024 মাতৃত্বকালীন ছুটি নিয়েছি। আমার বিনীত অনুরোধ, আমার পারিবারিক অসুবিধা ও শিশুর যত্ন নেওয়ার জন্য মাতৃত্বকালীন ছুটির ধারাবাহিকতায় সিসিএল লিভ ভীষণভাবে জরুরি। নবজাত শিশুর মানসিক উন্নতি ও স্বাস্থ্যের উন্নতির জন্য 7th December 24 থেকে 1st April 25 পর্যন্ত ছুটির আবেদন করছি। আমি নিতান্তই নিরুপায় হয়ে আবেদন করছি। So she applied on 4th of December. That was not allowed. Now, my lord, page 63. On 9th December, I resume my duty and again applied. Kindly grant me CCL from 10th December to 1st.
Your leave was from 10th June to 6th December. You joined on 9th December. Acha, Saturday, Sunday.
My lord, 9th December I joined. Again, I applied from 9th December. I apply from 10th December for CCL.
Where is that?
Page 63.
Page 6. Acha. Yes, then what happened?
CCL from 10th December to 1st April 2025. It's wrongly written as 24. It will be 2025. Now, my lord, that was not granted. Then I approached this honorable court. This honorable court passed.
So you were absent from 9 December. 9 December.
9 December I rejoined. From 10th December I am absent.
Achha.
9 December
So
I
you-
resume.
So from 10 December, you were not going to
My
school.
lord, my lord.
Why did you say 2025? It is rightly said.
No,
9
my lord.
December 2024.
In the application,
63.
1st April 2025, my lord. Page 63. Page 63 in the body of the letter, my lord. আমি 10th December 24 থেকে 1st April 2024. It will be 1st December 2025.
Oh, acha. You wanted leave for that period.
Yes, my lord, 120 days as per law, I am entitled, my lord,
Then
there
what
are
happened?
provisions. Now, my lord, this honorable court pass, I approach this honorable court, this honorable court pass. Now, what is the observation of this honorable court, my lord? May I read this order? my
Page
lord?
68.
Page 68, my lord.
অনেক বড় order.
My lord, I'm a relevant portion, my lord. I am praying. Now, my lord, page 70 from second paragraph. My lord, as per memorandum dated 17 July 2015 of the Finance Audit Department,
We have not got. Page 70.
page 70, second paragraph, fourth line. May I read, my lord?
Yes, the notification date.
Yes, they relied on notification. Court initially distinguished it, these notifications perhaps not applicable.
Yes.
Thereafter,
Memorandum of 17 July says that you are entitled to child care leave during the period for up to 2 children,
yeah,
18 years.
up to the age of 18 years.
How many days in a year?
760 days, 2 years.
In your
No,
entire
not
service
in the
period?
entire service period.
760 days.
Yes, in a year, 3 occasions a teacher can obtain the CCL.
3 occasions.
3 occasions.
So these two facts have been dated in 17 July. Notification.
No. 17th July notification is completely a different issue.
Next notification.
That deals with the Madhyamik examination only. Madhyamik and higher secondary examination only.
But
Nothing
next,
else.
the notification dated 20th. Yes, read.
Oh, no. This notification deals with child care leave. Yes. This notification, 17th July 2015, deals with child care leave. Yes, may I place that notification?
No, read.
Secondly, as per memorandum dated 2005 of the Finance Department, child care leave would be admissible during the entire period of service for taking care of up to 2 children up to 18 years of age, whether for rearing or looking after any of their need like examination, sickness, etc. The notification dated 23rd December 23 that was relied by my school authority only deals with the issue of examination and does not take care of either the question of rearing a child or sickness of a child. It has to be seen whether the said subsequent notification would have any overriding effect over the earlier memorandum and would stand the test of reasonableness and equality. The matter needs to heard at length. Opposition reply. In the exigent circumstances that the petitioner has to take care of 3-month-old child and she believes that she is a dire need of CCL of such purpose and there is sufficient days of CCL left in respect of her service, the petitioner shall be at liberty to make an application for CCL up to a period of 60 days within 23rd December 2024. The same shall be considered by the respondent school authorities within 3 days of receipt of such application. On the next 2 lines, it's very important.
Before that, kindly come to page 69, last paragraph.
69.
The decision rendered in earlier writ was there.
No, my lord, my Landlord-tenant denied one judgment.
Yes.
They relied one judgment.
One unreported
Lies
judgment was
with-
relied on saying that the interest of the students needs to be balanced. That has perhaps been not perhaps.
Yeah, then what happened?
Page 71, last 2 lines is very important, my lord. Page 71, first 2 line. If it is expected that the school authorities will consider granting CCL of up to 60 days to the petitioner favorably. It was the observation of this honorable court. Thereafter, I applied.
As a further interim measure, school shall provide for a room for all
Yes.
petitioners.
Because, my lord, what they have done, my lord, I am a lady clerk.
No, why this interim measure was
Yes, this interim measure because there are another issue. My lord, I am a lady clerk. My lord, the school authority, particularly the head of the institution, installed a CCTV where I am working. On the other hand, in the staff room, there is no CCTV.
So this paragraph has nothing, in fact, to do with your.
Presently nothing. Presently nothing.
Then what happened? কি হলো?
Then, my lord, pursuant to the direction of this honorable court, I applied.
You
Page
applied.
72. Next
Page
page.
70.
Next page. I applied for 60 days leave. My lord, kindly see, I am writing to request to for child care leave on and from 10th December 2024 for 60.
Come at 2.
My lord.
অসুবিধা আছে?
No, my lord, 2 p.m. my lord.
Matters fixed.
Two matters fixed.
I have also one matter fixed at 2 p.m. Malad.
32, another report number 9 and one
So
of.
we take it up at 3 o'clock?
Yes.
3 o'clock? You don't want.
No, sorry, certainly, my lord.
আচ্ছা শোনো বলো তো tell
Then, pursuant to the order of this honorable court, this is my application, page 72. I am writing to request for child care leave on and from 10th December 2024 for 60 days. That was the direction of this honorable court.
who is Devashish Giri?
Devashish Giri is my husband. Because I was unable to attend the school, that's why.
Then what happened?
And then, Malad, what they have done, Malad, kindly see their reply to such application. That is at page.
Dilo na. They have not given you.
Page 105, kindly see their reply.
One zero five.
Malad.
Yes, read.
My respected madam, I hope you and your child are doing well. On behalf of Bhadrakali Gandhi Vidyapeeth, I intimate you that considering your application for CCL dated 23rd December 24 and taking into account the humanitarian and sympathetic view towards your child, the managing committee has been approved for 21 days of CCL.
Consider page 70. 16 January.
Yes.
আজকে কত তারিখ?
Today is my 5th February.
March.
5th March. 5th March.
Then what happened?
Then the matter again came up.
So from 27 December till 16 January, you were granted.
Yes. Till 16.
So
only 21 days. Though court's specific observation are that I should apply for 60 days and school authority shall consider it favorably.
We have seen that.
My lord.
তারপরে কি হলো?
Then my lord, this matter.
So you matter mentioned came on 21st.
Yes.
Now what did
this order has been passed. My lord, kindly
so
sit
it was not given for 60 days, it was given for
21 days.
তারপরে
that is one aspect. My lord, another, my lord, when earlier in the year 2023, my lord, I obtained CCL when my first child was suffering from dengue. That CCL was granted. I enjoyed the CCL. Subsequently, the head of the institution, those CCL has been converted into medical leave. That's why I asked the court to produce the relevant documents.
Then let us hear him now.
My lord.
Why you have stopped salary?
Yes.
For the school authority.
Number one is.
Acha, let him finish.
Yes.
Then this order, my lord.
It is
without considering anything, simply posted the matter for hearing. After exchange.
No, it is submitted by the learned advocate representing the school. Petitioner has availed. 21 and thereafter friends has not resumed his duties. On perusal of the order, it appears made an observation that matter needs to be 60 din keno debe?
Yes.
Then when has the matter been fixed? Combined monthly March এসে গেছে তো।
Well, it will never be heard. Well, it's under the hearing after 2000 matters.
So you requesting or
I mentioned 2000, no hearing matter. Lordship is not taking any hearing matter. Lordship is not taking any of the hearing matters.
There are hearing benches also. আমি বলবো না এই লাইনে কারণ এটা আমরাও তো
Yes, Mr. Bose.
My lord, the facts of the case, my lord,
Facts বলতে না, why you are stopping, sir? Give it for 1 month. We will say hear out the writ petition.
My lord, as far as the stoppage of salary is concerned, I am taken by surprise before your lordships because this was not a point in the writ or any application or this appeal before your lordships. I have no instructions on that, except for the fact that I know that.
No, you have given 21 days. You have given
from 26th to 16th.
To 21 days.
Yes.
First court said His
Up to 60
entitlement
days.
is 60, however, school will consider.
Yes.
Because there is that issue of errant teachers who takes advantage and goes up. So you applied your mind and you said, I will give it for 21 days.
Yes.
But unfortunately, that reason does not appear to reflect from page 105. That why I have refused. One line refusal could have been given.
Yes.
Now, as you have not granted, automatically she will not get her salary. She has a
If
3 months old baby.
If the question is, my lord, of getting salary, may I point out the salary was not only, it was not deducted only because she, for the remainder of 20.
Deducted.
Not stopped. I'm sorry. It has not been stopped probably. Again, I say this because I am not on instruction. This is not a point. I am taken by surprise before your lordships because
So,
this is
Mr.
not
Bose,
a
you
point.
are our officer.
Yes, yes.
So you take instruction, come
Yes.
tomorrow, that whether, আচ্ছা বলছি তো day after বলবো, whether you can give this leave period, this is we are interactive, that if you give her leave for about 30 days,
Yes.
for that period, the procedure adopted for disbursement of salary will continue. And within 30 days, we will request the learned single judge to finish it up.
I will.
Our grievance also goes, your grievance.
Since it has fallen from your lordship, I will come with the
Yeah.
specific instructions. But, my lord, may I before that point out the case?
Our point out to give.
Lord, yes, I will come back. But even that will not suffice because she has not yet joined till now. Till now, she has not joined, and it is infraction of something which prohibits us from granting the leave. We are
Very
prohibited.
good, very good, very good. We will fix a time and date. She will go and join.
Yes.
You will sanction her leave finished. করে দেবো।
We have sanctioned.
Without prejudice to any rights of your to argue before the court.
Yes.
That more than 21 we could not have been
More
granted.
than 60 we could not have done. Number one. Number two is there is
He has covered 60 days already.
No.
No, yes, problem is 60 days was not as opposed to 21 days. 60 days was as opposed to 112 days that she had asked for. That was the first ground why we had to refuse. She wanted 112 days. We said that it cannot be done.
Rule
Wait, Mr. Wadi, we are trying to solve the problem.
May I place this for once because the confusion will be obviated then. 6th till 6th she was on maternity leave. She had come back on 9th. There was an unauthorized leave on 7th. 7th is a Saturday, which is a working day. She chose not to come.
Achha.
So on 9th, she comes, applies for leave from 10th and proceeds. Be that as it may, this was considered. Why it could not be granted is because, firstly, the policy says that the leave can be granted for 60 days. Number one. Number two is in exigent circumstances.
60 days in the
for up to. No. At one go.
Achha, at one go.
At one go for up to 60 days and in exigent circumstances up to 120 days. She had asked for 112 days. Problem is 60 days we could have had understood. She has not even said that there was any exigent circumstances. Number one. Number two is why we really could not allow is because of the Madhyamik examination which was going to start. We had to balance the convenience of the student. Keeping in view the fact that
we will say she will go and join.
Yes.
You sanction him leave pursuant to our direction for a particular period.
Yes.
We will say that and we will leave it open for further extension before the learned single judge, and we would request the learned single judge to dispose of the writ petition as expeditious. So you get then the problem solves, na? She will go and
another problem also which I am not inclined to stop her from getting any benefit. The problem is also of a discipline. She takes us for a ride.
We will make observations, Mr.
She takes us for a ride. That is the problem. And she has. I was not inclined to say this.
Mr. Bose,
I was not inclined to say this.
Mr. Bose,
yes.
It is not disputed that she has a child of 3
Not
months.
disputed. Never disputed. The problem
this is
is
an ego problem. Ego problem.
Hurt. With all due
both.
respect.
No, both.
I'll tell your lordships why.
He says, I will not bend down. I will not go to. I will see you in court.
I'll tell you.
When a constitutional court is saying it is expected,
yes,
yet you are applying your mind.
That is why.
You are applying your discretion.
Yes,
That
We
is
have that ego. We have
no, no, no.
noticed.
My lord, may I say this? That is why I wanted to place the
One constitutional court is said it is expected.
yes,
Yet you have got the authority to apply your discretion.
yes. That. হুম না 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 উনি তো ঠিকই বলছেন যেটা বলছেন যে পারসেপশনটা তো আমাকে দেখাতে হবে যে কেন তো উল্টো লাইটে দেখানো হচ্ছে
যেহেতু তোমার আগের অর্ডারে কিছু
6 থেকে 62 না হাই সেকেন্ড may I only
authority can
I am quite open to my lord this being solved, but if I may say this, my lord, the perception is
Mr. Bose, a court has given.
yes, I will come back with that.
No,
I'm
the,
sorry.
The way you deal with an order of court and the way the authorities deal, there is a sea of difference. This is a problem. You will immediately come and say, I bow down, I will talk with my class.
Yes.
But that ego is a very difficult problem.
May I only point out, since this perception of ego is, we could not have, this was not within our power. We are prohibited by an order of 15th of January. That was also brought before the notice of the learned single judge.
15 January, what?
15 January 2025, page 100. We had expected that this will be, because for the 34 years, our school is a,
Page
yes,
100.
yes, page 100 of the stay. Kindly takes up.
This is your 15th of January 25. Justice Sengupta passed the order in December 24. Achha, what is this notification for Madhyamik? So this hurdle is not there now.
May I say this, my lord? Each year, our school is a center for Madhyamik examination. Each year, we get this similar kind of notification saying that CCL will not be allowed unless your child is
Paragraph, which paragraph?
first paragraph of the order.
Page 100.
First paragraph of the order.
Teachers and non-teaching staff.
Non-teaching, she is also a non-teaching staff. The one we had relied on was a
Only
quite
under
some-
the circumstance when their child is a candidate of
different
any
issue.
other statutory.
Paragraph 1 is completely different issue. If
Again, you are, Mr. Badi,
no,
wait,
Malad,
let us
kindly see,
understand.
Malad, kindly see, Malad,
Yes,
kindly see.
Which
Kindly see.
paragraph, Mr. Bose?
the first paragraph of the point number 1 itself.
That is, if they will get may be granted if their child is a candidate.
Otherwise not.
ও কোথায় আবার otherwise not দিয়েছে?
Kindly read my lord further. May I my lord, also take your lordships through this. Paragraph 2 also.
Only under the.
Only under.
Yes, only. Only and only. That is the problem.
They have to show the
Yes.
proof that their child are appeared.
Paragraph 3, they will have.
Child leave, it is a rule
Yes.
and it is a notification.
Yes.
Not availing for same purpose.
Now, teaching and non-teaching staff is very tough to arrange the market.
Yes, and she was the only
Sent to the
yes.
Madhyamik center, it is
The-
very tough with the staff to arrange.
the other clerk had joined in December. If this also we had stated before the, and we have filed affidavits on that accord also. We have not yet received an affidavit in reply controverting, which I am sure they will file.
With all such eligible. ঠিক। আমরা নোটিফিকেশন ইস্যু করতে পারি। আমরা শুধু নোটিফিকেশন
So only thing is, my lords will. Oh, sorry.
Mr. Badi, this is a practical problem.
This was not. This is what we had.
Your problem is one problem. Their problem is on the interest of the students at large.
He is a non-teaching
Yeah,
staff.
can
not
I
the
work
teacher.
without my court officers being
Malad, he is a non-teaching
Badi,
staff.
whatever it may be, just consider.
She chose not to come. Chose not to come. Did not apply. Yes.
Is it possible,
No,
Mr. Badi?
7 except me, there are other 3 non-teaching staffs. Not only them, I am the only non-teaching staffs.
No.
Except me, there are 3 other.
No. Again, a misguiding submission.
That
They
is
have.
my that clearly stated in my writ application.
So, Mr. Badi, you are an employee.
My lord.
School wants some duties from you.
My lord.
If my court officer comes and tells me tomorrow that, my lord, I will take 8 days leave, will I not tell my court officer that though there are 2 more court officers, Please do not take, because court functioning will suffer. Court function is for the public at large.
Considerable, sir.
By way of an
Child of 3 months.
yes, that is why we are showing so many things.
Even then we have granted for 21 days, my lord.
Never took any other leave.
And my lord, the person, Mr. Giri-
Mr. Body learned advocate and you are appearing? Oh, it's old. Heard Mr. Body learned advocate appeared.
Yes.
My lord, since the last order was passed on 26th, thereafter on since 27th, some unreasonable stunts are being played with me. I do not know why, because as per my understanding, a proper hearing should have been given with regard to my application pursuant to your lordship's order. That was lordship's direction that
Let me
I
approach your
should be
lordship
given
about
a hearing. My lord, kindly cease.
what is the development, my lord? We have calculated his dues of subsistence allowance, that is amounting to rupees 5,69,000 and rupees 55. It is an admitted amount.
That is, my lord, till date June 2024.
My lord,
My lord.
We have some financial crunches. I want to hand over a check of rupees 2,25,000 presently. Lordship, kindly give us some time so that we can make the other payment. And Lordship, another thing, the authority is taking decision to withdraw his suspension. Let it be recorded.
My lord, I accept that. My lord.
So contempt petition disposed of.
My lord, my lord.
Huh?
Satisfied.
Undertaking.
Kindly, with his undertaking, kindly records that, my lord.
Let
That
it
is
be
the
recorded.
only.
That's why I have submitted.
Yes. That the amount has been calculated and 5,67,000 is admitted position.
69,000 and
69,055, that is admitted.
Yeah, You are.
I am Mr. Dotto.
Mr. Dotto.
Mr. Da is the advocate on record.
Senior, my lord.
More severe contempt.
Yes.
Deeply obliged.
Disposed of.
Great.
Now go.
We did not get anything.
ওনার আচ্ছা আচ্ছা আপনি
Not issued against me, Your Lordship.
against the alleged
Rule was only issued for contempt number one.
ঠিক আছে
Grateful.
Deeply obliged.
Item number 2. My lord, I am appealing on behalf of the petitioner.
So I am issuing rule.
Copy has been served.
Copy has been served. I am prima facie case of violation of the order has been made out. So rule is being issued.
May I submit my one instruction is there, Your Lordship. One instruction is there. I have shown it to my learned friend. They are in the process of filing the appeal. Now it's entirely up to me. I cannot say that. No.
It is
Choice
yours.
is I cannot say.
If you can get it stop, you stop. If you can't get it,
No, I'm never.
it will go. It is a contempt jurisdiction.
I am never submitting that my lord will not issue rule. Only thing, my lord, it was my duty to convey the instruction what they have.
I am not inclined to take cognizance of this. That what your alleged contempt has intended, has decided. Okay, I am prima facie satisfied that there is a violation of it. Whether it is willfully or not, that would be such and such before imposition of any punishment. Okay.
As my lord pleases, not I have nothing to say.
This instant contempt petition has been prepared alleging willful, alleging violation.
চুপ কর না
না।
ছিল না
না।
তাহলে আপনি করে দিন
অ্যাকশন করতে হবে
করে নেব 3rd April
3rd April
today's 5
yes
almost
almost 4
4 would be 5 according to, although it would be calculated subject to calculation. 3rd April almost 12. I'm thinking it is the problem of our country. Here who are at the higher stage, he feels sometimes what he enjoy, To
Possibly-
deprive the town totally.
Well,
Since
possibly,
1999,
this is
one after another order.
possibly, my
at
lord,
2020.
always this is not the right thought process.
We are inherited from the most.
No.
British or
I am for the petitioner.
Here for the
Petitioner. The last occasion, state was directed to produce the requirement of the whether that be form.
Who is appearing for the state?
Mr. Ganguly is appearing. Somnath Ganguly is appearing for the statement.
not today.
Item number 9.
19 members, I am for the respondent number 2.
You are respondent number 2.
Yes, ma'am.
Who is for the petition?
Kindly pass it to Madam Joint Sengupta is appearing. It's on the way.
Who is appearing?
Joint Sengupta. Short
Pass-
password, madam.
Password.
Item number 20.
I am for the responder 4, 5 and 6.
Is the Thika tenancy matter?
Yes, yes.
No, not.
He was here, my lord. He just
That was your Thika tenancy matter.
It was relating to the den control. After den control, they appealed before the matter LRTP, and this is the matter challenging the LRTP order.
Determination of rent.
Yes, not determination of blame. To whom I will pay the.
Oh, to whom you will receive. You are the tenant.
Yes.
All right, let him. Yes.
My lord, I am appearing for the petitioner, my lord. As per your lordship's direction, my lord, we are required to file the paper book. My lord, it is in the midst of preparation, my lord. We need 1 week time, my lord, to complete it, my lord.
So why should we extend the interim order then? 1 week time you want?
1 week time I want, my lord, kindly.
What is till March?
Notice আমার মঙ্গলবার স্যার তাহলে এটাকে ওই 19 তারিখ রেখে দাও 19th
Great,
Yes.
your lordship.
কোথায় সব Yes. নেক্সট 19 তারিখ দেখি কি অর্ডার দিয়েছে এই আইটেম নাম্বার 21
21 দেখে ফেলেছে।
হ্যাঁ 21 টাই 21 ডেকেছো তো লিস্টে 20 আইটেম 21
লিস্ট দেওয়া হয়নি।
My lord, 21. I'm appearing for the petitioner. Mr. Prabal Mukherjee is appearing, my lord. I'm praying for short password, my
Where is your reply?
reply. We have filed, my lord.
Huh?
We have filed.
Who is your other side? It will be on 19th. You give notice to the other side. Mr. The learned advocate appearing for the petitioners files the affidavit in reply.
That date 15. 2024.
শুনে নেবে।
Page number 11. Operative portion, page number 12. Last portion, my lord.
What happened? They have not passed any order. Consent order হচ্ছে তো পাস করে। The present contempt application has been filed alleging violation of an order dated 15th March 2024 passed by this court in WPLRT 44 of 2024.
Yoshiba, I appear on behalf of the alleged contempt.
Alleged contempt.
No one appears.
Complied.
No, Your Lordship, as per our instructions, the department is ready and willing to clear the dues, and perhaps they have taken steps. But that I have to take further instructions on that. If they have already paid the pension or not.
You have already
Communicated, sir, we are waiting for the instruction from the department, Your Lordship. Your Lordship kindly fixes a date within which we can come back with the further instructions.
we directed them to consider.
Yes, Your Lordship.
That also you have not passed.
Your Lordship, I have no instruction to that effect, Your Lordship. And I have already communicated the same to the department. We are awaiting the instructions. Kindly gives us a week's time so that we can come back with instructions.
No one appears on behalf of the petitioner, though such and such learned advocate appearing. এগুলোতে কি আছে 24-25? একটু দেখে নাও তো 25 অব্দি দেখে দাও হচ্ছে 24 who is for the petitioner?
I am for the petitioner.
Yes.
Well, they have complied, but the alleged contempt are not present.
That Rajashri Basu
No. That Howrah food
complied with. So we dispose of. Your prosecution. What order did we pass? You have filed contempt application?
Contempt application, my lord.
Contempt, alleging violation of order was of this bench, or it was referred to us, assigned to us?
No.
We passed the order.
Original order passed by my lord, Mr. Justice Dilip Kumar said as his lordship and Narayan.
So you are alleging violation of which order?
His lordship order to pay rent compensation until and unless the food can go down acquire permanently.
Now you have paid.
He earlier paid from 1st March, another 1 year due.
Acha, Mr.
Yes,
Dotto.
Yes, Dotto.
Mr. Dotto, learned advocate appearing for the petitioners, submits, comma, upon instruction, comma, that the order of this, that the grievance of the petitioners has been redressed. In view thereof, comma, we are not inclined to proceed with the contempt application any further, and the same is, comma, accordingly, comma, disposed of. And the same being is disposed of. Yes, next 25.
In this case, I am for the alleged contempt number 3. You secretary EPS. I have filed my power.
File it in the department. What is this matter, Mr.?
My lord, short time, both the parties have preferred an SLP. My SLP was taken up on 28th. There is a direction to take instruction as to whether state has any preferred any SLP or not.
So that was indicated on the last occasion. In fact, we have intimated also that an
My lord, this is the status.
Very hard.
No, defect has not been cured as yet, my lord.
Read petitioner have preferred and respondent number 2 has.
State of West Bengal has preferred an SLP.
We have been informed
on
by the
14th
learned
January.
we have been informed by the learned advocates appearing for the respective parties that
But I have got the from.
you are for whom?
I am from the
State.
My prayer was
So why you are not paying the other part of the order? Comply?
At the inception only I made a prayer that I am checked by the advocate general.
So what happened? Does it make any difference if the advocate general is appearing? We are concerned with compliance of our order. You ask your officer to be presented. Dekhi file to the.
The petitioner himself.
Yes.
Answer. Yes. And that is pending.
Are SLP and against a portion of the order.
That is saying, he is saying.
That is different. That is different. You have to intimate us on the next date whether the SLP date has been fixed or not, or you have simply filed it and kept it there.
SLP has been filed by one by the.
We know that.
Yes, ma'am. Has been attached together, and we issued a letter to the learned advocate on record asking her. No.
We are not concerned with that. We are not concerned with that. We want to know when the date has been fixed.
Yes, madam. We will inform Well, kindly fix this matter. and
You have to come and intimate us when the date has been
Yes,
fixed.
I will. Probably our matter will fix on their with their matter. I have to take information. That has been adjourned for 2 weeks as far as I'm for Union of India.
My SLP was taken up, my lord, I have stated.
Those have been tagged together.
No.
And it has been adjourned for 2 weeks.
Was the order
Kindly permit me to, I have got the,
Tagged with the SLP filed by the petitioner.
no, that has not been. My lord, the order in question, my lord, kindly permit me. Learned counsel for the petitioner is directed to ascertain as to whether the state has filed any special petition against the impugned order or not. Release the matter after 2 weeks. This is the order. On 28.
state was asked to inform whether SLP has
This
been
will filed by the.
Your Lordship, my
that
lordship,
order has
senior has the order, Your Lordship.
take it out.
This is the SLP filed by the petitioner.
When was that order passed?
28 February. Last Friday.
Arising out of. This is his petition.
Yes.
Yes, well, that is his petition.
So far, specially petition filed by the state, the defect has not yet been removed.
So you yourself prayed for an adjournment.
Yes,
Before
that is
this
the order.
No.
But go through this order, sir.
Yes, my lord. My lord, the order is with me, my lord.
Which order date you are saying?
28, my lord. 28 February 2025.
This order was passed on 3rd December.
Yes, my lord, that is
Yeah, earlier one. That order is not.
Now what is the next order passed?
after 2 weeks. Release the matter after 2 weeks.
2 weeks.
2 weeks.
So you proceed.
Yes.
2 weeks means when? Has it been said that
No, for 2
advocate,
weeks it comes.
what is the order reading?
Yes, my lord.
Whether
Unless-
state has preferred appeal.
Yes.
Then what does the court say?
Court says the release the matter after 2 weeks.
What is the previous paragraph?
Previous paragraph, Landed counsel for the petitioner is directed to ascertain as to whether the state has filed any special leave petition against the impugned order or not. Release the
Ascertain,
matter
directed to ascertain.
Question mark, there's a question mark after that.
after that.
And it will appear after 2 weeks.
2 weeks.
So when it appears, you intimate and bring
Certainly.
us the order.
We have it.
When it is appearing, your matter?
It appeared on 28, 2 weeks, 14th or 15th. It is supposed to come on.
Acha. Mr. Hussain, learned advocate, appearing for the petitioner submits
They PPR'd and sent it to me.
Uh-huh.
They PPR'd and sent it to me.
So keep it with you. Yes, next. ওনাদের নাম দিয়ে দিও appearance এ কে কে আছে। What happened? Yes, Rajashri Vasu.
That 24.
We have disposed of.
My lord, may I be
Order
permitted to
complied with.
record my- Yes, my lord, order complied. May I be permitted to record my name, my lord, 24?
এই ওর নামটা দিয়ে দিও,
961.
পাসওয়ার্ডটা দাও।
That I appear for the petitioner in this matter.
For the respondent number 2.
They are for the state.
এই লিখেছো এই পাস এই বলে দিলাম যে অ্যাডভোকেট অ্যাপিয়ার কার্তিক এটা একটু এই অর্ডার শিট গুলোকে স্টেপেল করে এইটার সাথে রেখেছি, এটাও সাথে। Yes, tell us.
Yes, my lord. My lord, the pleadings are complete in this matter, my lord. Just to give the facts of the matter, my lord, in a nutshell, my lord, one Bhaskar Ghosh has let out a particular property in favor of the respondent number 2 on 12th of January 2010. Now, my lord,
Let out to whom?
my lord, the respondent number 2, Mr. Shonjib Das.
You are the owner of the property.
My lord, I'll indicate that. I have subsequently purchased that part of the property from the heir of late Mr. Bhaskar Ghosh. My lord, on 12th of
No, you let Bhaskar Ghosh let it out to Sanjeev
on 12th of January 2010.
12th of January 2010. And you purchased on
My lord, I've purchased it on 12th of August 2015.
Devashish.
From yes, my lord, I'm Devashish. I've purchased it from Mr. Bhaskar Ghosh. Bhaskar Ghosh's daughter.
Devashish purchased on
My lord, 12th of August 2015.
Yes. Then what happened?
Now, my lord, 12th of August 2015 comes a little later, my lord. On 12th of January 2010, the tenancy was created in favor of the respondent number 2. On 12th of January 2011,
Just tenancy created.
Yes. The instrument of tenancy, my lord, will find at page 33 of my application.
Page
33 of my application.
Very good.
It was
Then
a
what
tenancy
happened?
agreement.
Then what happened?
Now, my lord, on 12th of January, just 1 year later, 12th of January 2011, Bhaskar Ghosh died.
Yes.
Now, my lord, I purchased Bhaskar Ghosh's share in the property by way of the deed of conveyance of 12th of August 2015, which your lordship will appear at page 37 of my application.
Yes.
So, well, subsequent thereto, I find, in fact, Malad, the deed of conveyance also provided that these are the tenants of the subject property. Now, this deed of conveyance, Malad, was executed by the wife of Bhaskar Ghosh, whose marriage with Bhaskar Ghosh stood dissolved, as the natural guardian of Bhaskar Ghosh's daughter, Medha Ghosh.
This held deed of 12th of August 2015.
Yes.
Taking permission from court.
Not taking permission from court, but my lord, that is something which I'll indicate that this particular deed of conveyance had never been challenged. Bhaskar Ghosh's daughter, Medha Ghosh, because this is the finding of the tribunal also, that she was 16 years of age when this deed of conveyance was executed.
So it was executed by the wife of Bhaskar Ghosh
As the
on
natural
her,
guardian of Medha Ghosh.
on her behalf and on behalf of her
Daughter. Now, let's subsequent to the purchase, I write letters to the respondent number 2. Now, my lord, one thing I would be required to indicate, because the deed of conveyance also provided that the respondent number 2 would be a tenant. Your lordship kindly takes up page.
We'll come to that.
Very,
Tell us the story
very,
first.
very. So, my lord, the deed of conveyance also provided that the respondent number 2 is one of the tenants. And along with this tenancy, the property is being conveyed in favor of the petitioner before your lordship. Now, my lord, thereafter, we write to the petitioner indicating that this property has been conveyed in favor of the petitioner. We write it to the respondent number 2.
When?
My lord, that was on 12th of February 2020.
After 5 years.
After 5 years.
You wrote to Devashish what?
I wrote to Shondip, my lord, the respondent number 2.
What did you write?
I wrote that I have become the owner by way of this particular deed of conveyance. This letter.
Attornment.
Effectively atonement.
Then what happened?
This letter was received by them, but not responded to. Similarly, a subsequent letter was again issued on 6th of July 2020. Reminder that I am the landlord now. You pay the.
To me.
Yes.
Then what happened?
Now, my lord, during the interregnum, we get to know that the respondent number 2 is tendering rent in terms of section 21 of the West Bengal premises rent before the rent controller in the name of the respondent number 3, one Lali Ghosh, who is a sister of late Bhaskar Ghosh. At that juncture, my lord, the section 21.
Lali Ghosh is the sister of Bhaskar.
Yes. Who has been married off, who does not stay in the property, has never staked any claim in the property.
So the 2 notices, when did they intimate you?
My lord, we have intimated them. We have become the owners. The first notice was issued on 12th of February.
We have seen that. Now, after 16 July 2020, what happened?
My lord, we found out that this rent was being tendered before the rent controller in terms of section 21 of the West Bengal Premises Tenancy Act.
Now, Lali Ghosh is before us.
Yes, she has been arrayed as a party.
Advocate has been engaged.
No. In fact, she has never appeared before any of the forums.
So the dispute concerns Lali and you. He is agreeable to pay the.
No, because, my lord, as we have indicated when we have opened our submissions, my lord, when we have moved the application, we had indicated that Lali, my lord, could not have been the person to whom the rent could have been tendered in the first place.
Right. So
Because Lali cannot be the linear descendant. In terms of the rights of succession, my lord.
So that has to be disputed by Lali herself, na?
Yes, my lord.
But Lali is not appearing.
My lord.
Lali was also not there before the trial.
Never, she has never appeared. She is also not appearing before the rent controller also.
This rent they have been paying continuously.
Now, my lord, there's one more thing which I would.
No, later
Yes,
on,
yes.
Lali, you came to learn that they are paying the rent in
the-
favor of Lali Ghosh.
Yes.
As per section 21 before the
Rent control.
But pertaining to which period? That must be subsequent to
Yes.
Bhaskar's death.
What happened, your lordship? According to their affidavit, a new tenancy was created. In fact, my lord, if I may take your lordship kindly through their application under section 21, which appears at page 72. This will lay bare the grounds which they have
No,
taken.
they have, then what happened?
According to them,
what did you do thereafter? After coming,
I have lodged an objection before the rent controller.
When?
My lord, that objection was, my lord, on my lord, that was, your lordship, on 16th of March 2020.
Very good. That was not considered.
I beg your pardon.
That was not considered.
It was considered.
Oh, considered.
Thereafter, the rent controller has passed an order.
In your favor?
No.
Achha, what is the date of that order?
That is 5th of January, my lord.
2020.
Just gives me a moment, my lord. 2021. That appears, my lord, at page 102 of my application.
So turn down your objection.
Turn down my objection.
No.
On the ground, the primary ground which had been taken was the entire gamut of the story depends, in fact, has been cooked up by the respondent number 2, indicating that there was a suit which has been instituted against the petitioners, challenging the deed of conveyance which has been executed in my favor. Since the daughter was a minor and that deed of conveyance could not have been executed. Both the rent controller as well as the learned tribunal below had proceeded on the premise that there was a suit which has been instituted challenging my title.
Now that suit has been preferred by the Lali. Is that minor
None
daughter?
of them. It was simply similar.
Lali, was this Lali the minor daughter? Or
No. Lali was the sister.
Oh, sister, right.
Lali was the sister, daughter was Medha. Medha.
No, whether it is the absolute property of Bhaskar or joint property.
My lord, for that my answer would be, he has accepted Bhaskar to be his landlord.
Landlord is totally one thing, another thing. Landlord.
What I'm on is, my lord,
the person who is entitled to collect the rent. Landlord means not a owner.
My lord.
Don't confuse.
My lord.
Agent can collect.
My lord, kindly, in that case, my lord, kindly takes up the tenancy agreement which was executed.
No, then what happened? That challenging that order, you went to the tribunal.
I went to the tribunal.
This 5th January 21 order, you challenged.
Yes.
Now tribunal passed the order when?
The tribunal, my lord, passed the order on
11th March.
11th of March. Grateful, your lordship.
11th of March order, you are assailing before us.
Before your lordship. 11th of March 2024.
So first take us to the order of the tribunal.
Very well. Very well.
It's a longish order.
It's a longish order, but my lord, your lordship will find the decisions with reasons from page 3.
Page, yes.
Because it's a 4-page order. The first 2 records the facts of the case, my lord. If your lordship permits me, I'll just place, my lord, the last paragraph at page 2, which is very important. Has your lordship got the impugned order, my lord?
Page 2.
Yes. Page 2 of the order impugned.
Which portion?
Just the last portion, my lord. It has the third last line. It has been stated in the application that title suit being number 816/2017 is in no way connected with the matter in dispute. Hence, the OA inter alia for an order setting aside the impugned order passed by the rent controller on 5th of January. So this was the suit, my lord, which they have alleged was instituted challenging my title over the property. And I have said that this suit did not concern with my title to the property. Now, my lord, the observations are the decision with reasons. I'll place that, my lord. Page
No,
3
no,
onwards.
before that, Mr. Sengupt, you say, do you have the plaintiff three titles?
Yes, I have annexed it by way of a supplementary affidavit, which is before your
Figures.
lordship.
Then place what you are placing at the outset.
Yes. At the outset of hearing, learned counsel for the applicant contended that he is the owner of the suit premises and respondent number 1 is a tenant under him, for which it is the duty of the respondent number 1 to deposit rent in his favor instead of respondent number 2. Malad, respondent number 1 is Shondip Dash, which is the respondent number 2 before your lordship, and respondent number 2 was Lali Ghosh.
Lali was 2.
Lali was 2.
Yes, then?
Learned counsel further contended that the respondent number 1, Shonjib Dash, was inducted by the predecessor of the applicant, visually Bhaskar Ghosh, by virtue of a tenancy agreement dated 12th of January 2010. And after the demise of the said Bhaskar Ghosh, the said, I'm sorry, Malad, demise of the said Bhaskar Ghosh, the present applicant purchased the tenanted portion from his legal heir, that is from the minor daughter of Bhaskar Ghosh. On this point, learned counsel for the applicant argued that the respondent is not a tenant under the respondent number 2. In spite of that, he has been depositing rent in favor of the respondent number 2 before the rent controller. Kolkata, which is not tenable in the eyes of law, for which the impugned order passed by the learned...
Just one. Section 21 eviction against default. Section now protection against default. Defaulter হবে না respondent number এর নামে আর object হচ্ছে to seek protection from disposition of default. You can see that.
Yes.
Yes. Now, Malad,
on this point.
Yes, on this point, learned counsel for the applicant argued that the respondent number 1 is not a tenant under the respondent number 2. In spite of that, he has been depositing rent in favor of the respondent number 2 before the rent controller, Kolkata, which is not tenable in the eye of law, for which the impugned order passed by the rent controller, Kolkata, on 5th January 2021 should be set aside and submitted that the deposit made by the respondent number 1 in favor of the respondent number 2 should be declared invalid. As against this, learned counsel for the rent controller contended that there is no illegality in the impugned order passed by the rent controller, Kolkata, on the score that the property in question is a joint property and it is still unpartitioned, for which the respondent number 2, the applicant and the other co-owners have the same right over the said property. Peruse the record meticulously, peruse the LCR and the impugned order dated 5th January 2021 passed by the rent controller, Kolkata, in RC case number such and such. On perusal of the same, we find that Bhaskar Ghosh was possessing the tenanted portion of the suit premises and he inducted the respondent number 1 in the tenanted premises by virtue of a tenancy agreement entered into between them on 12th of January 2010. After the demise of the said Bhaskar Ghosh, the property was purchased by his cousin, that is the applicant, from the minor daughter of said Bhaskar Ghosh by way of a sale deed dated 12th August 2015. At that time, the daughter of the said Bhaskar Ghosh was aged about 16 years. Challenging the validity of the sale deed dated 12th of August 2015, title suit being number 816/2017 was filed by the aggrieved parties, which is still pending before the City Civil Court, Kolkata. This is one of the aspects of this case. There is another side of this case. So now, Malad, pausing here for a moment, the first point of contention which was brought before the learned tribunal below was that there was a suit filed by the minor daughter against me, challenging the validity of the deed of conveyance.
Aggrieved party.
I beg your pardon.
Aggrieved party.
Aggrieved parties. Aggrieved parties as in, obviously, Malad, because the indication over here had
So
been...
that can be challenged by the sister also.
Malad,
Now, who were the parties to the suit? Do you know that?
Yes. That was a tenant who had sought for a declaration against me that he was he's a valid tenant in law. That is there in the supplementary affidavit, Malad.
816 suit.
816 suit.
That
was not a challenge to my title at all.
So was your title ever challenged by
Never.
Lali?
Never.
Lali has not challenged. but
Never.
my daughter has not challenged.
Nobody has challenged.
She has attained majority in the meantime.
Yes, because, my lord, your lordship recalls that is something which has also been considered by the learned tribunal below, that she was 16 years of age in the year 2015.
15, yes.
So naturally, my lord, as on date, she must be 26. And my lord, the law of limitation is as soon as she attains majority, within 3 years she'll have to institute the suit, which she has not. None of the parties have challenged my title to the property. The stakeholders, if I may say so. If your lordship kindly takes the supplementary affidavit which I have filed, my lord.
You have not finished the order. Next.
Oh, I'm so sorry, my lord. I'm so sorry. I just got... My lord, there is another side of this case. No evidence, far less than clinching, is forthcoming before us to show that before transfer of that property, the concerned parties, that is the applicant and the natural guardian of the minor daughter of Bhaskar Ghosh, took permission from the competent court. From the record, it is also conspicuous that the property in question is a joint property and it has not been partitioned by metes and bounds as yet, for which it cannot be said by any stretch of imagination that the applicant is the absolute owner, landlord of the tenanted premises. The respondent number 2 is also one of the co-owners of the joint property. That apart, the validity of the deed of conveyance dated 12th August 2015 has been challenged by the aggrieved, which is pending before the learned 12th Judge, City Civil Court, Kolkata. Pending decision of that title suit being this is the primary reason which has been rendered. Pending decision of that title suit being number 816 of 2017, it cannot be said that the applicant has become the absolute owner, landlord of the tenanted premises. The rent controller, Kolkata, in the impugned order, has discussed all the things in details. To avoid multiplicity of the proceedings, the respondent number 1 shall go on depositing rent before the rent controller, Kolkata, as before, until the property is partitioned by metes and bounds and the ownership of the tenanted premises is determined. On perusal of the impugned order, we are of the considered view that there is no illegality in it and there is nothing to interfere with the order passed by the rent controller, Kolkata. In the facts and circumstances, OA number such and such liable to be dismissed. Accordingly, the same is dismissed on contest, but without any order as to cost.
এই পয়েন্টে তো উঠবি মাইনর হ্যাঁ মাইনর নিতে হবে
That can be a ground for setting aside the deed. কিন্তু deedটাই তো
সেটা চ্যালেঞ্জ হয়েছে যে সিভিল
No, never,
Why?
never.
So this title suit 216 filed by
Filed by
tenant.
one, my lord kindly takes up my supplementary affidavit now, my lord.
You have annexed.
My lord, that was affirmed, my lord, on.
Then copy to him.
Yes, 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 all copies served. All copies served upon my learned.
কোথায় দিল? আবার
It was affirmed on 24th of June, my lord, 2024.
সাপ্লিমেন্টারি কি করেছে বলছে। একটা অপোজিশন আর রিপ্লাই করবে সাপ্লিমেন্টারি একটু নিচে দেখো দুটো কপি আছে না একটা
Yes, my lord.
আছে বাহ ইয়েস
My lord, that is at page 4, my lord. It's a certified copy of the suit, plaint in the suit, my lord.
পার্বতী দেবী মুন্দ্রা
Yes.
ঘনশ্যাম দাস মুন্দ্রা
Mundra.
মধু মুন্দ্রা very good. Now what is the scheduled property? That property?
My lord, the schedule will appear, my lord, at page 13. And your lordship may also have a look at the prayers, the relief sought for, which will appear at page 12.
Decree declaration that there is a monthly tenant in under Devashish.
You have very good suit.
So naturally, my lord,
You will be able to claim that treating me as a landlord, one person has filed a suit.
my lord, not only that, the issue over here is, my lord, just pausing here for a moment, consider the case which has been made out by the respondent number 2.
Subject matter is not the deed.
Not the deed. And the deed has never been a subject matter of any proceedings ever at any
Then
point of
how
time.
this person will get the declaration?
My lord,
How this tenant of yours will get that declaration if it is
my lord,
not
he has
written?
instituted the suit against me, accepting the fact that I am the landlord.
That is, but the property is different, you are saying.
Yes, the property is different, but at the end of the day, my lord, he has relied on the fact that.
The same premises, same premises.
Yes, this is one of the.
One tenanted premises. Under you, there was one tenant.
There were many.
There were many.
Under Bhaskar Ghosh, there were many.
So this Mundra was originally under Bhaskar?
No, this was under. This was also under Bhaskar.
Bhaskar.
Bhaskar. And now
he is paying rent in your name.
Now that this suit has been dismissed because there was a settlement.
Yeah, no, not settlement. Eviction suit has been filed and they have been evicted.
They have been evicted.
Oh, they have been evicted?
Yes.
Evicted.
Oh, the decree, my lord, is there at page 18.
Page 18.
I'm so sorry, my lord.
So what rent controller has order? What is the order of the rent controller?
The rent controller, my lord, has proceeded on the premise that this particular suit 816 of title suit 816 of 2017 has been instituted challenging my title over the property. And they somehow got the information because that, of course, that was the case. They were keeping a tab as to how the property was dealt with. They, at all material point of time, knew the fact that I have become the owner of the property. Otherwise, they wouldn't just quote a random title suit being instituted and refer regarding that before the learned rent controller and have also placed arguments, my lord, before the learned tribunal below.
Acha, in this suit, is there any reference to the title deed? Any statement?
Suit, perhaps, my lord. In this suit, they have. I'll just indicate once, my lord.
Now, the schedule is. Premises number is same. We checked it up.
Premises number is 4A Amor Basu Soroni.
4A Amor Basu.
Yes.
Yes.
And my lord, yes, it's the same. It's the same. The only difference being, my lord, the room number. In fact, my lord, perhaps what might come to your lordship's assistance is, my lord, the deed of conveyance. That your lordship will find at page 37 of my application. I hope I'm right, my lord. Yes. Page 37 of my application kindly takes up page 51.
Page 51 of the
application, my lord, this is the continuation of the deed of conveyance. A part of the deed of conveyance. This actually refers, my lord, schedule B, my lord. If your lordship kindly takes the page before at page 50.
50.
This is schedule B above referred to particulars of tenants. Now, my lord, entry number 3, your lordship will find at page 51, my lord, the first entry. Has your lordship's got it, my lord?
Very good. This is your point. Anything else you want to argue?
My lord, so Ghansham Das Mundra has been described as one of the tenants in this particular schedule, my lord.
Sandip Das is also here.
Sandip Das is also there, entry number 6. So the property was sold to me on as is where is basis, where there is no challenge to the title, to my title over the property at any point of time.
Ultimately, tribunal says that to avoid any multiplicity of proceedings, it says the respondent number 1 shall go on depositing before the rent controller until the property is partitioned by Miscellaneous.
Yes.
Anti-ownership is determined.
Ownership is determined.
Now, my lord,
Ultimately, admittedly, property is a joint.
for that, my lord, it is not an admitted position, my lord. That is what I'm trying to indicate. The tenancy agreement which has been executed and has been admitted by the
What is
Lali has got no stake in the property.
whether the Bhaskar was absolute owner or it is a joint property.
My lord kindly takes up page 33 of my application.
But that suit is not
Until the property is partitioned by Mitts and Bound. You are not saying, you have not
Now, my lord,
another joint property, Landed Tribunal observed. I have seen joint property.
Yes.
Is a joint property.
Yes.
So if you think that this observation of the tribunal is yes, come to decision with property in question is a joint property.
now, my lord,
All co-sharer will. A deposition, that will be deposition in name of all. That will be deemed to be deposition.
evidence.
তুমি বসো না, দাঁড়িয়ে পড়ছো কেন? আরে ভাই আসো, লালি তো একজন ফার্স্ট ক্লেম। না না, লালি বলছে তো শেয়ার আছে। লালি one of the joint.
If I
Lali is one of the joint.
Now, my lord, just if your lordship bears me for a moment. It is an admitted position that my learned friend's client was a tenant under Bhaskar Ghosh. Bhaskar Ghosh.
Yes, you have purchased the share of Bhaskar Ghosh. You purchased from
Not only
all legal heirs of Bhaskar Ghosh. So what title Bhaskar Ghosh had only can be conveyed to you, not more than that. So if the property is a joint property, Bhaskar has the half share, then you can get only half share, not the entire.
Now, my lord, what is the case of that of the respondent number 2? He has admitted Bhaskar to be the sole owner of the subject property. Now, I was indicating, my lord, to the tenancy agreement.
Admission will not give you title or ownership.
I'm not on that. But my lord, your lordship will also consider the point that it does not solely vest the title in favor of Lali. I also become a joint property owner.
You show us Calcutta property, SSC report or anything like that you show.
In that case, my lord, that is not on record. If
So that you are
what I'm trying to indicate over here is, then in that case, my lord, I'll produce that particular document if
so the issue regarding the ownership is pending.
it's not pending. That is what my contention is, my lord.
Totally.
There has been no challenge to that. If I may conclude my submissions and thereafter, my lord, এটা দিয়ে কি হবে?
The ownership of the person.
ওটার সাথে এটা কি সম্পর্ক?
এখানে ওর ownership-টা admit করে suit পাইবে।
That determines that the suit is a joint property, property is a joint.
সুটটা যদি joint property থাকে, is restricted to the share of আমি যেটা প্রশ্ন করছি যে ওটা যদি জয়েন্ট প্রপার্টি হয় তাহলে ভাস্করের পোর্শনের ম্যাক্সিমাম ল্যান্ড অফ টাকা joint property.
My lord, it is a joint property.
So if it is a joint property, so if it is a joint property, then he becomes a tenant of the joint owners, irrespective of the tenancy agreement. In that event, the portion which in respect of which he is depositing the rent, you can at least submit that it should be in both of our names.
My lord, that is now what I'm contending, my lord.
Pardon?
That is what I'm contending, my lord. Because
Do you agree now that yes, if he deposits in the name of myself and Lali, it will be all right?
my lord, my name needs to be recorded. Because, my lord, even assuming but not admitting that he says that Lali, the property stood in favor of Lali and he has tendered rent in favor of Lali. Now, pausing here for a moment, my lord, his contention at all material point of time had also been that Medha is a daughter. The property was, so naturally, my lord, Medha was a linear descendant of Bhaskar Ghosh. What he ought to have done is,
So in the unpartitioned property, Medha becomes a part of the property owner.
yes, now, my lord, as soon as Medha conveys the property in my favor, my name ought to be recorded.
Right. If it is recorded, then you cannot be exclusively the person who would be entitled to the rent. Then the factum of Lali's share, we cannot shut our eyes to that.
My lord,
Lali's share, we cannot shut our eyes because it is a case, it is a joint family.
now again, my lord, the estate, in that case, my lord, the law would be the estate stands represented. The estate, because it's a joint estate, that stands represented. If Lali is not there, I'm also there. My name needs to be recorded.
If it is recorded, this deposition is made for all co-sharers of the property, then your purpose will serve.
Just gives me a moment.
Not whether your
Because my name also is required to be recorded. That is what I'm on.
deposition, though deposition is being made in name of Lali, but such deposition would be for the all legal for the
And not exclusively for Lali.
Yes, not
you will be
exclusive.
satisfied.
Your name will be
I'll
there.
just take instructions on that.
Lali would deposit it.
My learned friend, Malad, just has prompted me to indicate one thing, because in that case, the suit court also, the civil court also has arrived at a conclusion. Malad kindly takes up page 18 of the supplementary affidavit. Page 17, in fact, Malad.
If he can prove that he is one of the co-sharer, then he will get. We shall not name. A deposition.
So the deposit has to
be deemed to for all co-sharers of the property, since it is a joint property.
Malad, rather, if I may say so,
No, that serves your purpose, na, Mr. Singh.
Malad, that ought to, but my learned friend is
all right,
just indicates me to show one point. Malad, the decree which has been passed in title suit number 816 of 2017, Malad.
Page 18, yes.
Yes, page 17, Malad, it's again a copy of the certified copy, Malad.
Is Mrs. Infectious?
Yes.
Infectious in the sense he has already left the possession.
Yes.
So infactual. So here right and title has not.
No,
been
my lord,
determined.
I'll just place that once. It is contended by the defendant number one petitioner that in a suit for ejectment filed by the defendant number one against the plaintiff number one before such and such, a decree of ejectment and recovery of khas possession was passed in favor of the defendant number one. A copy of the decree is relied upon by the petitioner defendant number one. It is further contended, that is, a decree was already passed in my favor in a suit for recovery of possession, that is ejectment suit number 318 of 2017. So the civil court, my lord, has arrived at a conclusion that I am the owner of this particular property. My lord, just the second paragraph, it begins, it is contended that the defendant number one petitioner in a suit for ejectment filed by the defendant number one, that is me, against the plaintiff number one, which is the plaintiff number one in this suit, before the Presidency Small Causes Court, Calcutta, being ejectment suit number 318 of 2017, a decree of ejectment and recovery of khas possession was passed in favor of the defendant number one.
As landlord.
That is me, as the landlord.
Landlord, but not as a owner.
My lord, of course, my lord. What I'm trying to indicate is at all material point of time, my lord.
You take instruction whether this will suffice or not. We will explain the order saying whatever deposit is being made, it should be deemed to be a deposit in the name of heirs of Bhaskar, in which your name will also be there.
Or the successors in interest. Or the successors in interest. Because I will, of course, my lord, be the successor in
Your
interest.
purpose is to see that their purpose is that it does not become a bad deposit so that they can get a protection.
My lord, they have already got the protection. Reason being, I'll tell your lordship.
Oh,
We have instituted a suit. There's a 717.
We will clarify this order to that effect. We will clarify the order to the effect.
Because what is happening, my lord, is before the learned court, below the civil court where I have instituted the suit against my learned friend's client for recovery of possession. Over there, they're challenging my title, citing this particular order.
Oh.
That is the difficulty, and that is
Yes,
what is
sir,
pinching me.
The dispute is very simple. First of all, your lordship already satisfied that this is a joint property. So I need not go to the
We are
street.
not satisfied as yet.
Yes, my lord. Very well, my lord.
We are not yet satisfied.
Yes,
That is recorded.
my lord,
By
kindly
the
come to the
order in PS.
We are wanting to be satisfied.
my lord, kindly come to my lord, page 42. This is the number, page number. Page number 42 once. Of the my lord, read petition.
Page 42.
This is the my lord, deed of conveyance on the basis of which they are claiming to be the owners of the property. My lords, now kindly, my lords, kindly come to my lords, paragraph 2. And whereas the said Gopal Chandra Ghosh.
42. This is whose deed?
This is the my lord, deed on the basis of which they are claiming to be the owners of the property.
They have purchased.
Yes, my lords, from the my lords, legal heir of the my lords, Bhaskar Ghosh.
41. Gopal Ghosh and Surya Kumar Ghosh.
Yes, my lord. The second paragraph.
Possess of.
Thus seized and possessed of 5/8 share, 1/2 by partition deed, 1/8 by inheritance, in the said divided and demarcated southern portion of premises number 4A. And whereas the said Gopal Chandra Ghosh died intestate on August 2004, leaving behind himself surviving only son Bhaskar Ghosh and only daughter Lali Ghosh as his heirs, heiress, and legal representatives under the Hindu Succession Act 1956, and left his undivided 5/8 share in the said premises, his wife predeceased him. And whereas Bhaskar Ghosh the seized and possessed of or otherwise well and sufficiently entitled to 5/16 share of the property. Now,
Fine. Where are you reading? Page 41.
42, my lords. 42, my lords, I was reading.
Paragraph?
Second paragraph. And whereas that upon such date
of Surya, the said Gopal seized and possessed 5/8 share, half by partition and 1/8 by inheritance. Very good. Then Gopal died August, leaving behind
only son Bhaskar Ghosh and only daughter Lali Ghosh.
So Bhaskar will be getting that 5/8 share.
5/16 share. 5/8 share has been divided between Bhaskar Ghosh and Lali Ghosh.
Oh,
Bhaskar Ghosh is entitled to my lord 5/16. Lali Ghosh is 5/16. And that will be my lord's. Yes, my lord. And the next page as well, my lord. Page 43.
Yes. Because the schedule itself says, Malas, the undivided 5/16 share in the property. Schedule is at page number 49. All that undivided 5/16 share in all that piece or parcel of land. So it is undivided 5/16 share in the property they have purchased. So this is a joint family property. Laligos has also share 5/16 share. And each and every co-owner in the undivided property regarded to be the owner in each and every portion of the property until partition. So Laligos is also an owner of the co-owner of the tenanted premises.
Acha, where is that rent controller's order?
Rent controller's order. It is at final order is at page 104.
Page 104.
Yes.
102 would be the page.
102 it starts. And 103 is the relevant portion.
Yes.
Paragraph it is marked as 5 as per description in page number 5 of the deed of conveyance. Therefore, the question of co-ownership exists, which cannot be ignored by this rent controller court. Yes.
The rent controller has no jurisdiction to determine ownership unless civil suits are disclosed. Entitled to receive a तो पिक्चर এর অবজেক্টটা কি যদি that deposit declared এটাই হচ্ছে তো আমরা তো এক্সপ্লেন করে দিতে পারি এটা the deposit which is being making because shall be deemed to be a deposit will be
yes. Now, if this clarification is made, will you be prejudiced?
Yes, I will be. Because if your lordship has the Premises Tenancy Act, if your lordship kindly comes to the Premises Tenancy Act once.
without premises tenancy act. Premises tenancy.
Now, which provision you got?
Was definition of landlord.
Landlord, yes.
2C.
Read.
Plus landlord includes any person who for the time being is receiving or is entitled to receive the rent for any premises, whether on his own account or on account of or on behalf of or for the benefit of any other person or as a trustee, guardian or receiver for any other person or who would so receive the rent or be entitled to receive the rent if the premises were let out to a tenant. Although this provision doesn't require the landlord to be a owner of the property, but rent is the incidence of the tenancy. To whom the rent is paid is the landlord. Rent is the incident of tenancy. To whom the rent is paid, she shall be regarded as the landlord. If your lordship now, kindly comes to section 2G, tenant. Tenant means any person by whom or on whose account or behalf the rent of any premises is or but for a special contract would be payable. That is only important, my lord. That is only important. Who is paying the rent is the tenant.
No, I didn't follow. What did you say? 2G?
Yes, my lord.
2G is the definition of
Yes, tenant. Yes, my lord. Tenant says, my lord, any person by whom or on whose account or behalf the rent of any premises is or for, but for a special contract would be payable. Which
Yes.
paying the rent is tenant. So,
Yes.
rent is the important thing.
So very good. We will only clarify
Yes.
that you will go on depositing in the name of Lali, but that shall be deemed to be a deposit in the name of all the co-sharers.
That is why I'm saying, because landlordship doesn't mean ownership. I have paid rent
We
to
are with
Lali
you.
Ghosh.
We are with you. It does not mean ownership.
Yes, that is why I have
No.
paid rent.
What you are apprehending? If it is done, what problem will you face?
Because they have filed an eviction suit against me, saying that they are the landlords. Now, if your lordship clarifies that my deposit will be also considered deposit in their name, so that to tantamounts to be that they are also the landlord. Now that will be a difficult position for me, because I have disputed their landlordship.
I'm not saying so. Lali is deposition is being made in name of one of the co-sharer.
Yes.
Of the land.
Yes.
It is a joint property. He has purchased undivided property.
Yes.
Or undivided fifth
5/16.
5/16 share of the property. So the deposition which is being made by you, it would be the deposition on account of all co-sharer. And we shall not say whether he is landlord or he is one of the.
It is unpartitioned. He cannot be.
That is why, my lord, I am saying, because landlords, as per the definition of Premises Tenancy Act, doesn't says that the person to be a owner. Because if your lordship now says
Exactly, that is why we are saying.
Yes,
exactly. That is why we are saying ownership will not be determined till the partition suit is over.
Yes,
even at all, if partition suit
yes,
is
Manoj,
there,
that is why I am saying, Manoj, that will not be an important thing. Because Manoj, I paid rent to the Lali Ghosh. That is the important thing. That would determine the tenancy.
You are worried whether that your deposit will become invalid or not.
Yes, obviously.
Yes.
They have challenged that, because they have challenged the other
will not
co-sharers are not here
become
before your lordship.
Does our clarification makes your deposit invalid?
Who inducted you?
Yes, Manoj.
Who inducted?
My predecessor in interest.
Oh, Manoj, as per the agreement,
Vasco?
as per, yes.
So he's claiming title under Vasco.
Yes.
Now, as per 116, whether you have 116 evidence,
Manoj,
whether can you challenge the title
Manoj,
of the person who inducted you?
Bhaskar Ghosh has died. Bhaskar Ghosh is has the share of undivided 5/16 share of the property. Then there is also Lali Ghosh. So after the death of Bhaskar Ghosh, I have paid the rent, and Lali Ghosh has accepted the rent. So Lali Ghosh becomes the landlord, and a new tenancy is created. 106 doesn't arise, man.
No, deposition you. At least on the ground of default, default they will not count will be available to you. Ownership, it is not your.
That will not prejudice you.
That is why, I am saying, because if ownership is not important, if that would be that is regarded, the deposit is regarded.
So what will be done? So long the suit does not attain finality, people will remain silent and seek no declaration. Whenever the point is taken, you will take this point.
That is the point.
Then there will be no end to litigation. You are saying, you are arguing a point that it is in oblivion. You are saying if there is a partition suit, you have admitted it is a joint property. If upon partition only you can claim exclusive ownership, we address that issue. That is why we were not granting him the relief.
Yes,
we will clarify that.
Only I am saying that if Mallard's ownership is not, if the Mallard only.
Why should we go into that argument, sir? Tell us, why should we go into that argument?
Because Mallard, I am.
You will not be prejudiced in any manner.
Because Mallard.
Will you be prejudiced? Ground of default can they take after this clarification?
Because Manoj, if this deposit is regarded as in their name as well, they can take Manoj, and obviously they can also say And they can also say that he is, my lord, my landlord. Because rent is the incident of tenancy, my lord.
So your deposit will not be invalid deposit.
My lord, yes.
So you get protection.
My lord,
What you are apprehending is.
and now the situation is, my lord.
Whoever the actual owner, it is not your level.
My lord, one another.
Now, whether he will be evicted or not, only on the ground enumerated under section 6. 6, if the condition or ground enumerated under section is fulfilled, you will be evicted, irrespective of fact who is the owner or not. That is here. Your deposition against the portion you tenanted to you or demised in your favor, that is obvious that you are depositing rent against the portion of the premises demised to you.
Assessment
And my lord,
116 ধরিয়ে কেন dispute title করবে?
and my lord, one another fact, my
You
lord.
bring that assessment rule.
I'll bring the
My
assessment.
lord, one
Now, my
another
lord,
fact, my lord, I am now, my lord.
All right, let him bring the assessment
My lord,
rule.
I am now paying rent before the, my lord, court. Because, my lord, they filed an eviction suit against me. My lord, we have filed, my lord, section 7(1) application that has been allowed. So, my lord, we have now paying rent before the, my lord, court, not before the, my lord, rent controller.
Very good. Very good. You have already got protection.
Yes.
I beg your pardon, your lordship.
No, he was saying that in that he made a 7(1) application. Rent
Yes,
has
that they have already filed.
My lord, just, my lord, may I take one instruction so that, my lord, your lordship can dispose of this matter.
So now it is ball is in the court of now.
For the civil court, my lord, there's only one thing which I am required to point out, my lord. Kindly see, takes, my lord, section 21 once of the West Bengal Premises Tenancy Act.
Tender, if used, then can tender.
My lord, whether it's a bona fide tender.
Oh, bona fide.
Section 21, subsection 3, which I am on, my lord. Because this is what can be the case. Because, my lord, I'll also show one part. I'll just place
There is a bona fide
doubt as to the person or persons to whom the rent is payable. The tenant may deposit such rent with the controller in the prescribed manner. Now, my lord, what is the case, the section 21 application which they have filed? My lord, that appears, my lord, at page 72 of my application.
So now the situation has changed.
No, what I want to indicate, my lord, is they have, despite, because that has been their consistent stand.
We decide the validity of such deposit here.
No. I'm not saying that, my lord. What I'm on is the rent controller would decide whether the deposit is valid or not. From that, I go before the learned tribunal. Thereafter, the learned tribunal has passed, according to me, my lord, an erroneous order, from which I'm before your lordships. Now, my lord, the issue over here is they have filed a section 21 notice, a section 21 application before the rent controller, saying that Lali was the owner, solely Lali was the owner, and there was no other owner, and they have tendered rent.
There was no other owner.
That was their contention, my lord. Kindly,
Clarification.
I beg your pardon, your lordship.
And hence we are making clarification.
That is what, my lord, what I'm on is Lali was not the owner. He, at all material point of time, had been aware of the fact that Medha Ghosh was the daughter of Bhaskar Ghosh. He has not jointly tendered rent in favor of Medha Ghosh and Lali Ghosh.
Eviction suit was filed.
Yes.
He filed an eviction suit, my lord.
Now, what they're trying to do over there is they're challenging my title.
So now, as per the order passed under 7(1), you are filing a
Rent before the, my lord's court.
deposit in the court.
Yes.
So, what is?
Where is that application?
Yes, my lord, that appears, my lord, at page 72.
Stand sheet.
72 of my application. Whereas their stand all along had been that Medha has challenged my title. I'm placing it, my lord. Page 72 is the section 21 application filed by my learned friend's client, that your petitioner is a monthly tenant under the aforesaid landlady. My lord, landlady finds that is Lali Ghosh. She has been addressed as landlady, opposite party owner.
ও তো double standing আছে।
Landlady in respect of one room at a monthly rental of rupees such and such.
লালির নামেই দিয়ে দিচ্ছে। Refused to, then Lali refused.
And my lord, at the cost title, the juror portion itself, she has been arrayed as an owner.
Yes. Where?
So it has been their case that a new tenancy had been created. That is their case in the affidavit also, in affidavit in opposition, which has been filed before your lordship.
Landlady opposite party owner.
Owner.
But one of the
No, because their affidavit, my lord, before your lordship says that a new tenancy has been created. That is what I am against. My lord, kindly seize, my lord, their affidavit in opposition, page 7, paragraph 13. That is what I'm on. That it's a new tenancy which has been created, and that is the reason why they have tendered rent in favor of Lali Ghosh.
Paragraph?
My lord, paragraph 13 of the opposition, my lord. That this this respondent states that he was initially a tenant under Bhaskar Ghosh. They accept. And after his demise, his sister, namely Lali Ghosh, directly his sister, because the brother has expired.
Having equal undivided share.
No, their undivided share over the tenanted premises, accepted this respondent as her tenant, and accepted rent from this respondent in respect of the tenanted premises, and a new tenancy was created between the respondent number 3 and this respondent. This is what, my lord, they're citing before the civil court where I've instituted the suit for eviction. That is what they're on. That is what the scheme of things is. That a new tenancy has been created by Lali Ghosh in their favor. That cannot be the case, my lord. That is what I'm on, and that is why I'm before your lordship challenging the order of the tribunal.
But Mr. Sengupta, even we accept that, how can we accede to your prayer that let the deposit be made in my name only?
My lord, what I'm on at this juncture is perhaps that cannot be done, but what can be done is, of course, the recording which has been made both by the learned rent controller as well as by the learned tribunal below. Because that itself is is based on an erroneous premise that they have their approach had been such that Lali Ghosh has created a new tenancy in their favor, which is not the case. Because if at all, my lord, at one hand, what is a sauce, my lord, for goose has to be a sauce for gander as well. Over here, at one hand, they say that Lali is the owner and she has created a new tenancy in their favor. On the other hand, they try and seek refuge of the defense that this was a joint property, so I am a tenant under everybody. That cannot be the case, my lord. That is what my humble submission is.
What they have stated in their written statement.
Written statement, my lord, that has not been brought on record, but if your lordship permits me, I will.
Yes,
I will.
brought on record.
Huh?
Whether
Oh, that has been annexed. That's been annexed. That has been annexed. I'm so sorry, my lord.
That has been annexed, my lord.
To their opposition only, my lord.
that new tenancy they have pleaded, the new tenancy, new agreement.
Page 26.
Page 26. Okay, that issue will be determined by the civil
Yes,
court.
my lord.
Yes.
Landlord tenancy dispute will be decided.
No, what I'm on, my lord.
You have taken much more time.
My lord, what I'm
Clarification that the deposition which was made on behalf of by the tenant, you get it? Maybe in name of Dali, but it will be on account of all posted. Since the property is a joint. Except this, yes, and presently.
and my lord also records, my lord.
Judicial notice from your submission that presently the tenant concerned is depositing rent in court as per the order passed on application 7.2.
And one more point.
No, invalid. 7.2 the order, 14 order.
বুঝেছি, দাঁড়াও।
ওই জন্যই তো ক্লারিফাই করে দিচ্ছি unless property as a mission bound and ownership of the tenanted portion is determined. ওটা ইয়ে হবে সেটাই বলতে চেয়েছি
No, my lord, my primary challenge, my lord, is mounted as against my lord. My primary challenge is mounted as against the recording, my lord, in respect of title suit number 816 of 2017.
Okay.
That, my lord, also clarifies that it has not got no bearing because I've produced the records before your lordship. The suit,
That your submission we will record.
my lord, also records. I've also, my lord, annexed it to my supplementary affidavit, the certified copies of the plaint as well as the subsequent decree, my lord, which has been passed. So naturally, my lord, title suit 816 of 2017 has got no bearing regarding my title to the property. It does not challenge, my lord. That is what has been recorded by the learned rent controller as well as by the learned tribunal below. That title suit number 816 of 2017 challenges my title over the property.
Holding that, it has become infactuous. No right and liability has been determined.
But my lord, my lord also considers this fact that that very suit does not challenge my title, which has been recorded by the learned rent controller as well as by the learned tribunal below.
Degree was hold. Degree was drawn up.
My lord, decree was not. I'm in.
Where is the degree?
That has been annexed to my supplementary affidavit. And my lord kindly considers the plaint. The plaint does not relate to any challenge to my title over the property.
Supplementary. So as the degree of that order that infectious. Where is the degree?
The decree, my lord, is at page 70.
It is degree.
In respect of title suit 816 of 2017. It has not perhaps been drawn up as of now, but it's a certified copy.
We want to see the degree. What is degree?
My lord, that is what I submitted, my lord. It has not been drawn up as of now. So obviously that cannot partake the character of a decree. But my lord, the suit, the plaint which I've shown.
By which right and liability of the parties will be determined.
Now, my lord, I am not on that. The suit which has been instituted, your lordship will consider that. It is not relating to my title.
That submission will record.
Very well. Not only the submission, my lord, because
one thing, my lord, since the my lord suit is pending, whatever observation your lordship is making, my lord, we
Cannot.
can't be, my lord,
Cannot.
in any way, my lord, in affect the suit, my lord, because the my lord, they have said he is the my lord landlord. I have disputed my lord landlord-tenancy relationship.
That will not affect. That is
And
law.
that will be my lord decided in the my lord trial.
The present application has been kindly hear the order. Present application
no challenge has been posed to my title over the property, but just that recording, my lord, of the learned rent controller as well as the tribunal regarding title suit number 816 may also be nullified, my lord, because that affects to an extent, my lord, my right, because that has been recorded by the learned rent controller as well as.
Recorded that suit is pending.
No, there's no suit pending challenging my title.
Oh, title suit was 8116 is pending. They have,
No.
They have observed the same.
They have observed the same challenge, holding that was a challenge to my title over the property.
Exactly. That has been recorded in the order.
My lord, if not mistaken, my lord, title suit 816 has not been referred to. What your lordship has recorded was there is no challenge to the title of the petitioner before any forum. If not mistaken, perhaps that is what has gone in. Yes. So as on date. So
what you want to incorporate?
Well, that title suit 816 of 2017, it has been recorded that it is the challenge to my title over the property. Because
the trial court has.
Landlord, he's not the sole landlord. He's not the sole owner. So how will it affect your suit? Your suit will be eviction to be governed by section 6 of the transfer.
Because the deposit is in the name of all these co-sharers.
Yes, it will be deemed to be a deposit in the name of all the co-sharers.
Because in the
You are entering into your prohibited area. And hence we have referred 116 of the evidence act.
We have not recorded that.
You are unnecessary entering into this dispute.
That will.
You only will enjoy the property. You will pay the rent.
In any event, the trial court will decide that. The trial court will decide that whether I can challenge that or not, because I have said the same thing before the return statement. The trial court will decide that whether I can take the plea or not. Because
that stopped you from taking the
because this is a issue of to be decided
how
after.
can you say that it is not a joint family property? That is the argument you advance.
I am saying that this is a joint family property.
Yes,
At the same time,
we are recording that you are challenging the title of all co-sharers except Lali, and the trial court will consider whether this challenge will come within 116 of the.
I am not saying that. I am not saying that.
We are just recording this thing.
I am not saying that. I am saying that because I have shown to your lordship section 2(2) of the Premises Tenancy Act.
What order? Only clarification that the rent which has been deposited by you with the rent controller shall be deemed to be a deposition for all co-sharers or on where? Now, how your suit will be prejudicial?
Section 2(2) of the Premises Tenancy Act.
Section 2?
Section 2(2) of the Premises Tenancy Act, definition of landlord. They will say because rent has been.
Turning into the definition into landlord.
Because I have said
you are depositing under section 70.
Section 21.
Now under section 72.
Section 21 I have paid. Section 72 now I am paying. Because but I am paying in the name of the I am paying.
How will you be prejudiced, sir?
Because they will say.
Okay. Based on your submission, we are just recording that you are now denying the title of this person, and this denial as to whether will come as a denial under section 116 of the Evidence Act or not shall be considered by the court below.
If I say him, one thing, I am not saying him as the owner.
All right, we have passed our order.
Kindly don't observe that.
There are three matters, 3 contempt applications, 3 review petitions, and 3 section 5 application.
Who is
Lord,
opposing you, Mr.
one, Mr. De. Mr. De, Chandicharan De, he is opposing.
You ordered daw to it.
My lord, contempt number 561. My lord, that 661 in connection with the review petition which was filed that has been awaited. So they have not taken any step. My lord,
These pleadings have been complete.
my lord, pleadings have been complete in other two, but in one matter, my lord, they have not taken any step for substituting the, my lord, the,
Our earlier order has been complied.
my lord,
Reply,
my
file.
lord, everything. And matter, my lord, starts from a civil CO.
Mr. Roy, give a notice and come. This will take some time.
My lord, he was there. My lord, if he doesn't come, my lord, yes.
He was there.
He was here just before this matter. And he says that I have come to attend this, but since the matter is going on, so I am leaving. That is the casual approach. My lord, the matter which is now, my lord, very clear to issue a contempt rule in 661, my lord, where there is no, my lord, existence of any review application because that has been awaited. No step has been taken by the state, my lord, to impede the legal heirs of the petitioner. So, my lord, that should be proceeded, number one. Number two, if your lordships, here the section 5 application, my lord, then section 5 application, we have filed our opposition and we are opposing to the application because, my lord, there are,
reply.
my lord, they have submitted their reply. Whether they have filed this before this honorable court or not, that we do not know.
All right, come tomorrow.
Tomorrow.
No, tomorrow হবে না, সোমবার দিনকে রাখো, Monday.
Well, Monday, Lord, some upgradation.
It will be in the supplementary list. Yes. টা কি গো? ওইগুলি কি আপডেটেড? 44 থেকে ডেকে দাও একটু, 44 টা ডাকো।
Well, 30 is one of my matter. 30.
46 একটু দেখে দাও সাপ্লি লিস্টটা 46 থেকে 29 টা কি?
So item number 29, I'm praying for not today, Lordship. Mr. Dibendra Chat is appearing for the respondent writ petition, Lordship, is not come to the court, Lordship, due to personal difficulties.
29.
I'm praying for
29, why Dipendu at the time you are taking? This
Lordship.
Mr. Jana was there.
No, Mr. Dibendra Chat is appearing for the writ petitioner respondent, Lordship.
Rich petitioner respondent.
Yes.
He was appearing in person, na?
29.
No,
That person came and said that I will do it.
Lordship, I'm for petitioner.
Mr. Chatterjee was appearing, Lordship. Mr. Dibendra Chat is appearing, Lordship.
29 is Maheshwari Vidyalaya.
Lordship.
Appellant,
No, no, writ petitioner respondent. Respondent.
Oh, this person is standing.
Maheshwari Vidyalaya আমরা
Most probably appointment of a group D or anything.
Group D
like
employee,
that.
Lordship.
Huh?
Lordship.
Not today.
Not today.
Lordship. Public.
Item number 32 and 33. Can it be fixed? Well, I've been suffering a lot, Maladon.
ও মুখটাও তো গাছ মাছ করতো পাহাড়ি না কাম তোমরা ওই অ্যাডভোকেট জন আছে না
Advocate General and Mr. Talukdar is there, Malad. Kindly, Malad.
Date.
আচ্ছা ডেট দেখো তো ফিক্স করে দাও 27 তারিখ করলাম না, 27 তারিখ করলাম।
Day after tomorrow.
We will fix a date and time. 20 শুক্রবার লিখুন তো 3:30 হয়ে যাবে, চলে যাবে। 26 fix আছে, 25
My lord, except 12 and 13.
আর কোনো দিন সোমবার
কবে?
We'll keep it on 24th March at 2 p.m.
My lord, item 30 also, my lord,
Done.
kindly.
24 March দুটো।
Item 30, my lord.
কি অর্ডারটা করতে হবে?
33 একসাথে।
At 2.
Mr. Roy, don't worry, contempt we will take it up in supplement.
No, not contempt, not contempt. 30, item 30 is an assigned matter pending since 2015. My lord, I will be waiting.
Session will take you to the month of April. We are making an endeavor. If we can get hold of that matter, we shall do it.
My lord.
If not reached, we are there.
এই দুটোর সময় বলেছে 24th at 2.